Thank you. Good morning. Good morning, everyone. My name is Christopher Trebilcock. I'm serving as the presiding judge for today's panel. I'm joined by my colleagues, as you just heard, Judges Seema Patel and Randy Wallace, both like me from the Second District of the Court of Appeals. We welcome you to this first day of our case call here in Detroit for December 2025, and we are case call panel number 1. Bit of housekeeping is we are going to skip number 1 on the docket. There was a scheduling conflict, and counsel for that matter is over in the other panel first, and then we'll be calling that case out of order later. So just be mindful of that. With that said, we recognize that these cases are important to all litigants and counsel that are here today and those who are not. Often our decisions are the final word on the dispute or problem that gives rise to each case. And I can assure you that we have been diligently working on each case called today, and we have had the benefit of your briefing in our preparation for today. We have a full schedule today, and I want to cover some basic ground rules. First, each party will be allotted 30 minutes aside if you are opposed and 15 minutes aside if you are unopposed. If you see me looking down, it's because I'm trying to keep time on my watch or on my phone. Second, if there is more than one attorney on a side arguing, please let me know how you'll divide your time at the outset before you start so I can keep track of that. Third, for the appellant, let me know at the beginning if you would like to reserve time for rebuttal. And fourth and final rule is that if your case involves children, sexual assault, or other sensitive topics, please do not mention the parties or children's names. Instead, please refer to them by initials or other private identifiers. As you should all know, this is a recorded public hearing and will be posted on YouTube. My last comment before we call the first case is my advice based on over 20 years of practice before this court and my brief time on the bench. And my advice is this. We are very familiar with all the relevant facts and the pertinent case law involved in your case. I highly recommend that you focus your limited time on the specific issues that are dispositive to the outcome and to address specifically any of our questions today from the bench. With that, we will call our first case, which is number 2 on the docket, case number 365-696, People of Michigan versus Damia Amani Foster.
Good morning, Your Honors. Angeles Meneses from the State Appellate Defender Office on behalf of Damia Foster. I raised 4 issues in this brief, and I'm going to focus on issues 1, 2, and 4. Those are the first 2 issues of ineffective assistance of counsel, as well as the sentencing issue, unless this court has any questions with respect to the 3rd issue of ineffective assistance of counsel, the failure to call witnesses.
Any questions in that regard?
Okay.
Go ahead, counsel.
Okay. First, Your Honor, the prosecutor misrepresented the evidence surrounding the circumstances leading to the decedent's death during closing arguments, characterizing it as Mr. Glover was running around, literally running for his life at the time of the shooting, or the stabbing, was unreasonable and unsupported by evidence. It is not a reasonable inference from the evidence based on where, for example, the box cutter, the keys, and the glasses were at the scene. And this limited testimony by police officers as to where all that was set out cannot support the inference that Mr. Glover was running for his life at the time that this death happened.
Dive in a little bit more for that on me, because the record I read was that there was evidence and testimony that the box cutter was not opened, that his glasses were found in one place and there are other items. And the way I read the record and the way I interpreted it was that it was, it was not all in one spot. It was spread out across the front lawn, which suggests at least there was activity in more than one area of the front lawn.
There certainly was activity, Your Honor, and that would correlate with Ms. Foster's testimony as well. She did not say that this was just a simple incident where, for example, Mr. Glover approached the door, the stabbing occurred, and that was the end of that. She does contend that he did have a box cutter, which is agreed to by all witnesses that testified. The only discrepancy is whether that box cutter was open or not, as Your Honor stated. Ms. Foster testified that it was open and that she did see that it was open at the time of the stabbing. The officers claimed that when it was on the lawn, when they found it later, that it was closed. It's unclear whether that happened after, just as a result of the scuffle, or whether that was always the case. It's not necessarily also the case that these items were kind of strewn far apart from one another. The box cutter and the glasses were actually near one another. The keys were a little bit further away, but the way that the prosecutor characterized it was that these items were strewn about, indicating that Mr. Glover was literally running around for his life.
Can you give us some context? Is there any testimony in the record you can point us to in terms of, how big the lawn was and how far apart these items were? I mean, were they all within arm's length of the victim's body, or were they, 15 feet apart, 10 feet away? What's the record?
My understanding from the officer's testimony is that these were all within arm's reach of each other, although they weren't necessarily all in one place. They were not 15 feet away from one another. There is nothing in the record to indicate what the size of the lawn was. But the fact that these items were not strewn about as characterized by the prosecutor, they actually were, for the most part, pretty close to one another and would correspond with Ms. Foster's testimony and account of what happened.
And what about the testimony about the victim having defensive wounds?
Yes, and that was so the officer did testify. There was no basis really for that testimony as a medical professional, but he did testify that they appeared to be defensive wounds because he had scratches on his hands. However, Ms. Foster also had wounds that could have been characterized as defensive wounds as well. So all of that would have corresponded with what all the parties kind of agreed happened here, which is more or less a struggle between two people that ultimately culminated in a stabbing and not just a straightforward stabbing. Second, Your Honors, trial counsel failed to request a jury instruction to instruct the jury about the past incidents of violence by the decedent here. Although they were instructed as to prior bad acts by Ms. Foster, this was not enough to instruct the jury on what to do with the past acts of violence that they heard of that occurred by the decedent towards Ms. Foster, and how to contextualize those amongst what happened and kind of understand her perspective at that point and why she felt the need to defend herself that day. Third, Your Honors, trial counsel did fail to file a sentencing memo, which deprived Ms. Foster of a fair and meaningful opportunity to present very relevant mitigating factors before the court. Ms. Foster had a history of mental health issues, depression, anxiety, as well as a history of domestic violence, some of which occurred at the hands of the decedent.
Wasn't there testimony about some of the past history of the domestic violence in the record? I mean, the victim's father testified that, yeah, there had been fights amongst the two.
Mr. Glover Sr. testified that there had been domestic violence incidents. However, he attributed those to Ms. Foster. He claimed that there was one time where he saw Ms. Foster put her hands on Mr. Glover Jr. There was nothing Ms. Foster testified about the previous incidents of violence by Mr. Glover towards her, including when she was punched in the mouth and her braces broke, the incident involving the gun at the hotel and those things. But there was nothing to corroborate that testimony because trial counsel did fail to kind of investigate and call any witnesses that might have been party to those incidents, which is addressed in issue number 3 of the brief. If there are no questions, I will. Thank you.
Thank you, counsel. The case is submitted. Now calling item number 3, case number 373-805, People v. Stephen Lewis Till. We have, did council check in? No one's checked in? No one's checked in. That case will be submitted on the briefs. Now calling case number 4. Item number 4, case number 372-439, People of Michigan v. Willie Lee Lucas.
I made it. Good morning, Your Honors. Gary Strauss, on behalf of Mr. Lucas.
Okay, give me 1 minute for you to get on our screens.
Okay.
There you go, sir. Would you like to reserve any time for rebuttal?
Yes, and I'll be fairly brief and my just highlighting an argument or two here. Yes, Your Honors.
You want to call it 2 minutes?
Yeah.
Go ahead.
Oh, okay. Well, it appears that the main issue here was that the prosecutor asserted that the statements by the EMS technician, Ms. Carter, were necessary for medical treatment. When Ms. Edwards said that she had her eye had been injured from a forceful blow to the orbital area. But that statement, first of all, I don't believe that it should be that expansive for medical treatment. She didn't even provide an ice pack or do anything. So it seems like a conclusion, looking for a basis, basically, that it was necessary for medical treatment, which in my experience, occurs quite a bit, to kind of skirt around the rules. And it was more pronounced in this case because she did not appear, and it didn't appear that defense counsel knew that she wasn't going to appear till the 11th hour. And there was no show of diligence for not having her appear in court, anything of that nature. So it really had no ability to confront the witness. Yes?
Counsel, would you agree that if we could find it admissible under 803 subpart 3 or 803 subpart 4, then there is no error if we would find either subsection applies?
Well, certainly if this court decided that it was legitimately came in under the rules of evidence, yes, it would.
So address for me and for us the under subpart, and I may have flopped these now in my mind, 3, your argument is that the statement wasn't necessary for treatment?
Yes, Your Honor.
That's 4, subpart 4. Yeah, sorry. Under subpart 4, your argument, your primary argument is that the statement in response to EMS saying, "How did this happen?" And she said, "I got punched in the face." You're saying that wasn't necessary for treatment.
No, it wasn't, and I think the facts bear that out. Not that I'm looking in the future and trying to determine what happened in the past here, but there was not even an ice pack given. And when the prosecutor in the brief, they talk about, well, it was necessary because she might have been whatever. I don't know exactly what she said, but different procedures might be done. It might be MRI or X-rays or whatever. But apparently, that was not apparent when EMS got there and saw it, and not even an ice pack was given. So to me, it seems to be backdooring in this evidence, which is more pronounced in this case because there was no testimony. So he couldn't defend himself against that.
Would you concede that that EMS was necessary for them to check her out at some basis, that she had some apparent injury, or that it was necessary to review what was going on with her?
Well, certainly to observe any injuries, anything of that nature, and that would be necessary for medical treatment. And again, I think it's kind of a subterfuge here. Yeah, definitely. I mean, if the EMS was called, that's Ms. Carter's job, see if she needs aid. But
help me understand then how, if EMS comes up and they sit down with a patient or potential patient or victim, that just saying, "Tell me what happened," so they know whether to examine a leg or a head or a shoulder, how that sort of general statement isn't, and her response, how that isn't necessary for medical treatment.
Well, the way that it happened, no, I don't think that was important for medical treatment. She was looking at it. Um, I didn't see any testimony where she gave her any testing or whatever. She looked at it and did not even provide an ice pack. So how could, why would it be necessary to know how it occurred?
Well,
Um,
pretty much every medical record has a history section, right?
oh, no, I agree, Your Honors. The medical records,
And there's a reason why they have a history section, right?
yeah, I would assume so. I would assume so. If I may respond though, the argument is not whether it's good for a medical record or what they put down. It's whether it should come in basically as testimony to a witness that cannot be examined, by claiming that it's for medical treatment. But I think clearly it was not.
And what's your best evidence or best argument that the victim's statement was to provide testimony or to provide support for the investigation versus just being part of the sort of medical history and in response to questions from EMS? I didn't see any evidence in the record that EMS talked to the police beforehand and said, hey, go ask all these questions so we can figure out what happened here.
No, I would agree with that. Again, I think the bottom line is though, she received that information and it was used at trial, not in her job, part because she's not an attorney, she's not in court then, she's not supposedly, she was rendering assistance, seeing what was going on. So I don't disagree with any of that she wasn't, she was doing her job, but to come into court and testify to that, which was a big issue in the case, it was only two witnesses in the case and not the complaining witness. So, no, I agree that, the EMS, she did her job and that's what she was there for. And
Wasn't
I
that-
agree that it might be in the mental history along with a lot of other things, but
So doesn't that fit squarely into 803 sub 4?
Well, the case law that I cited, I don't know if I would read it verbatim, but it wasn't a statement of existing a mental, emotional, or physical condition. It wasn't a statement regarding that. It was relating to the cause and how it happened.
Wouldn't I just suffered trauma to my face be a statement of present physical condition?
Yes. Yes, I would agree with that. But how it happened,
In the face.
right? But how it happened, I don't think so. I think there should be a line there. Because then the rule becomes so expansive, as I'm sure the court's aware. I mean, so much stuff comes in. It's not often for the truth asserted, but we all know that it is, But I'm kind of beating a dead horse. I agree with what everybody is saying. But again, it goes to the heart of the case. And coupled with the fact that the witness was not there, no efforts were made, and then they could say later, well, we didn't need the witness. Because we had everything we needed from this statement that was necessary for medical treatment that was never even given. Yeah, I know I'm repeating myself over and over again, but we keep going over the same thing. But if they come and see that our eye is hurt, would it matter? I mean, I got a horrible immune disease. One of my friends said, it's the COVID shot. Somebody else, a mosquito, but it doesn't matter to me how it happened. It happened. It exists. So it's that kind of thing.
Yeah, I think we understand your argument as to that point. Is there anything you want to add regarding the confrontation clause?
No, other than the fact that without the witness there, he can't confront the EMS's statement as to the veracity of that or whatever,
Okay. Any further questions? Any further questions?
No, thank you though.
Okay, thank you, counsel. And you still have ample time for rebuttal.
Morning,
Thank
Your
you.
Honors. Assistant Prosecutor Danielle Walton from the Oakland County Prosecutor's Office representing the plaintiff appellee, the people of the state of Michigan. I just want to respond briefly to defense counsel's argument, but it appears that the court understands our position is that this statement falls squarely into the state hearsay statements for the purposes of medical treatment.
What about the witness herself? What kind of due diligence was there to get that witness to court?
So the defendant's argument here is that the statements don't come in because it was a testimonial statement, and because under 804, it would require the victim's presence. So here, if the statement was admissible under 803, if we look at 803, the following are not excluded by the rule against hearsay, regardless of whether the declarant is available as a witness. So we don't have to produce the witness. And if it's a non-testimonial statement, we also don't have to produce the witness. So to me, that defense counsel is arguing that the statements don't come in, but under our theory of prosecution, the presence of the victim is immaterial. And to respond specifically to defendant's argument that it's not necessary for medical treatment, here the paramedic responded, saw the injury to the eye. What was critical when you have a punch to the eye, which was the genesis of the injury, is the paramedic had to rule out the possibility of concussion. And so they checked that the eyes were equal and reactive, and that's on page 14 of the transcript. And the court, and she also checked the victim's vitals. So here, this is for purposes of medical treatment. This court, even though it's an older case, found it was an identical treatment or identical statement in People versus Creeth, I've been punched, was admissible for the purposes of medical treatment. And ultimately, this court reviews, did the court abuse its discretion? So was it within the discretionary call of the judge to find that this would be admissible under that hearsay exception? Now, as to the claims about testimonial, here, this falls squarely into this non-testimonial realm of evidence. This is an emergent situation. It wasn't law enforcement officer. And for some of the same reasons, it was admissible as a statements for the purposes of medical treatment. This was not for a testimonial purpose. The primary purpose of what the paramedic was doing was not for the purpose of creating testimony relevant to a later prosecution. And I think something that really supports the people's argument is the victim didn't say who did it. So here she was just responding to basically, what's the genesis of your injury? I was punched in the eye, and that was the...
Was this paramedic cross-trained at all? In terms of, was the paramedic also a police officer?
No, there was no testimony that was true. It doesn't reveal. I'm sure that would have been brought out, but no.
Okay.
No. So it's just a paramedic. It's unlike, so we have some of the cases about sane nurses, like we have Spangler and Garland. And even when you have a nurse that may be somewhat cross-trained, this court in Garland said, well, ultimately the purpose is for medical treatment. And here, even more so when you have a paramedic responding to an emergent scene and treating the victim in this case. If this court has any further questions regarding any of the other issues, I'd be happy to answer them. Thank you, Your Honors.
No questions. Thank you. Counsel, you have time for rebuttal?
Just briefly, I don't think this statement falls squarely within medical treatment. Again, for the reasons I've stated, probably over and over again. So I would rely on my brief. I for this has a couple other points to make, but it would not be purely in rebuttal. But I think we made all the points in the brief.
Okay.
So I would rely on my brief for the rest of the arguments.
All right. Thank you, counsel. Any questions? Any further questions?
Oh, thank you.
Thank you both for good briefing and great oral argument responding to our questions.
Have a good day.
Thank you.
Docket number 4 is submitted. Do we have counsel for item number 1? Is he back in our courtroom, or is he? Item number 1, case 372003, People v. Rudy Ashton McFall. Counsel's not here. All right. That's okay. Let's move to docket number 5. Case number 374639, People v. Andrea Dramba. We have both parties certified for oral argument. Only one person checked in. You may approach.
Good morning, Your Honors. Marilyn Day, Assistant Prosecuting Attorney representing the people of the state of Michigan. Because defense counsel is not here, I'll answer any questions you might have, but the basic premise of my argument is the judge should not abuse of discretion in deviating from the guidelines based on the proportionality. The 2-year sentence was proportionate in this case, and it was proportionate based on the defendant's background. If you're looking at the OV and the PRV scores, it was a very low guideline score. It was 0 to 9, but he had a prior offense and a subsequent offense. As indicated in the pre-sentence investigation report, he was involved in a criminal enterprise to put skimming devices on ATM machines. And in this case, there were 13 different ATM machines. He had a prior offense for the fraudulent transaction devices, and he had a sentencing that was after this where he had other ATMs. So the judge in this case looked at the surrounding circumstances, looked at the fact that the guidelines were so low in this case, and all of his cases are concurrent. So the time he's getting for all 3 of these cases, which includes 13 counts in one case. So that is not our case, and another.
That's the subsequent case. Those are the subsequent cases, right?
Yeah, and the one that was sentenced after was the prior. So they're all kind of in the same realm of time. One thing I did want to note that I did not put in my brief, and I apologize, is the guideline deviation is not as large as we would think. It looks like it's a 15-month deviation. It's only a 1-year deviation because under the statute, there's a mandatory minimum of 1 year. So if it so basically it's a 12-month deviation in this case. And the judge basically doubled it, finding because of the PRVs and OVs did not take into account all this other criminal activity that he was involved with. And if you look at the OV score was 0, and if you look at the ones that weren't scored, they didn't score number of victims. We have no idea how many victims were involved in this skimming operation. The amount of money that was lost, that was not scored. OV3, or OV13 was not scored because presumably because this was a crime, it's classified as a crime against public order. So they didn't talk about the crime against property. So none of the OVs were scored whatsoever. So the 2-year sentence in this case fulfills the requirements of SNO, the deterrence, punishment. It was not an unreasonable sentence in this case, and I would ask this court to affirm the sentence.
Questions? Any other questions?
Thank you.
Thank you.
Thank you. The case will be submitted. Just checking on docket number 1, case number 372003, People v. McFall. Has counsel returned? No. Okay. Moving on. Item number 6, case number 371394, Elizabeth, and I apologize if I'm cutting off part of the last name, Iki versus Bobby Festus.
Good morning.
Counsel, your appearances for the record, please.
Yes, my name is Richard Aliff. I'm appearing on behalf of Elizabeth Ogunareka Omowaveze of Appleland.
Counsel, do you wish to reserve any?
Yes, I would like to reserve my remaining time for rebuttal. I'm thinking maybe 5 or 10 minutes.
Okay. Proceed.
As the court is aware, wife has waived oral arguments in companion case 372981, but because the facts and the issues relating to the IRS levy are identical in both, for clarity, I will continue to refer to the numbers collectively. The only issue unique is the sales tax, which I will not address unless this court has questions. This case turns on simple math, lack of proofs, husband's judicial admission, and most importantly, federal preemption. The IRS personally served a notice of tax levy on wife, which under binding federal law preempted wife's ability to pay husband under the judgment of divorce. And when the wife obeyed the levy under federal law, the trial court ruled ignoring her supremacy clause and preemptive arguments. For context, the trial court had before 2 components to the payoff. It had the $40,331.13 for the House of Attorney fees, which is undisputed, and it had $450,000 for the business buyout. quickly reduced to $330,000 with the timely first payment also undisputed. At that point, the judgment of divorce allows wife a choice. She can either pay the remaining $330,000 in 3 installments, or she can pay $280,000 in full satisfaction of the $330,000 if it's paid by May 31st. A sizable discount of $50,000. And this is where the confusion originates, because the levy is served right in that time frame. Now, husband's response correctly points out that there was a status quo order that preserved the $50,000 discount until further order. Husband, though, never even remotely raised the discount or a forfeiture discount argument in any pleading or in any of the 3 hearings, bringing it up now for the first time on appeal, which constitutes waiver. But even aside from waiver, a lost discount theory is unsound. First, the math doesn't add up. Only minutes before the ruling, the trial court was informed that the $50,000 discount was the only thing that was on the table. Everything else was paid. If the trial court believed the discount was lost only moments later, it would have awarded $50,000, not $40,331.13. A lost discount theory also does not align with the record. On the one side, we have the status quo order, which preserves the discount until further order. And on the other side, we have the further order, which does not vacate the discount and which says wife did not violate the judgment of divorce by following the IRS levy.
Counsel, help me do the math in terms of, in total, let's say she gets full credit for the payments to the IRS. That amounted to about 320, right?
320, yes.
320 and some change. And she already paid another timely payment on that amount, right?
We start with 450, and from that we take off 120, which is admitted.
Yep.
And that leaves 330.
Okay.
And the issue really here, I think.
And
is
so
the
doesn't
discount.
she, I guess I get to my point is, at the time of the trial court's decision, wasn't there, even if she gets full credit for the tax payments to the IRS and what she had paid with the first installment, wasn't there still an amount still owing, even with the 50K
No,
timely
no.
discount? Okay,
There's only an
explain
amount
that to
owing
us.
if the discount is forfeited.
Okay. And explain that, walk me through that math.
Okay, so we start with $450,000 for the business buyout, minus 120 admitted, leaves 330. If the 50,000 is not forfeited, that leaves 280. Then we have the attorney fees and the house proceeds of 40,332.13. Add those two together, we get 320, 331.13, which is the exact amount husband has admitted to receiving in his verified pleadings.
Okay.
So I was mentioning that on the one side, there's the status quo preserving the discount until further order. On the other side, there's the further order, which does not vacate the discount, which says wife did not violate the judgment of divorce by following the IRS levy. And in between, the record shows the trial court is aware that following the IRS levy means paying the IRS what it is demanding, which is a total of 320, 331 and 13 cents, specifically earmarking a discount of 280,000 for the business and 40,331.13 for the house and fees. And this is made clear to the trial court and the husband in wife's pleadings at Appendix 305. Husband never confronts the IRS about the discount. As the record shows, the wife had the money available as early as May 6th anyway. Maybe that's why he didn't confront it. But the controlling issue here is that the trial court ignored binding federal law. Wife's brief cites several portions of the record demonstrating that the trial court was fully appraised of the preemption argument. But in addition, the record contains numerous other references that further establish the trial court's awareness and consideration of the argument, including Appendix 308, 365, 370, 416, 482 to 488, and 526 to 527. None of those citations raise any new issues on appeal. They just simply underscore that the trial court had full notice and relevant authority and argument regarding the preemption at the time she rendered her decision. Among the authority referenced in White's brief and before the trial court is Biondo versus Biondo. Supremacy clause preempts state law, and federal law controls over state law, even in divorce cases. Beek versus City of Wyoming. When preempted, state law is without effect. Internal Revenue Code 6332, a levy reaches both property and rights to property.
Yeah, Counsel, we're very familiar with the cases you cited in your brief. Could you address the issue raised regarding how the sale of the Mercedes was handled and the issues that
That's a non-issue.
okay,
The IRS
explain that to us.
So initially, the IRS was wanting the automobile and also demanding that the wife turn over the keys to the automobile and the Roth IRA. But as husband's counsel pointed out in his brief, or at least in the lower court, the IRS cannot take an IRA. There's so many procedures. And then with regard to the car, the revenue officer backed away from that because the revenue officer said she didn't want to go through all that. That's basically what happened. So the IRS backed away from the car and the Roth IRA, but continued to demand the house proceeds and the business buyout.
Okay. What about this issue that the husband brought up that somehow the way the transfer, because if I understand the plain language was that she would transfer title. The issue, as I read it, husband saying that she didn't comply with the consent judgment of divorce because she didn't effectuate the transfer in the proper manner. And based on that, he incurred 2,000 and some change in terms of
No,
tax penalties.
with respect, the allegation was he was responsible for the sales taxes. And he was claiming that wife would not put zero down for the sales price. And wife's response to that was she can't put zero down for the sales price. The sales price, right on the document itself, it indicates
Well, wait,
that
was this post judgment or pre-judgment?
prejudgment.
Because they're related, so she could have put zero because she's a relative.
But Michigan law says she cannot. And the rationale is that the sales tax on an automobile is not excluded. It's exempt. So the state of Michigan makes the determination of whether or not it's exempt, and it does that based upon the sales price or the market value, whichever I think is less. But you have to put down a number unless the fair market value of the vehicle really is zero, which it wasn't.
So you put down a number, but if you're a relative, you might be exempt.
Correct. Yes, that's all husband had to do was claim the exemption.
Okay.
And he probably did. In the record, we supplied the husband with the paperwork necessary to get the money back.
Yeah, I think we understand that piece of it. Thank you for clarifying that.
Okay, thank you. And then in the United States versus Phelps, which is really the controlling law that wife was faced with under federal law, at the moment wife was served with the notice of levy, the marital property and rights to property came into constructive possession of the United States. And at that moment, wife becomes custodian for the United States, subject to severe sanctions if she doesn't timely comply. Also at that moment, the state law becomes without effect to the extent it conflicts. So to follow the levy, wife complied with the IRS demands. It was the IRS who recognized, applied, demanded, and accepted the discount. Wife had no say in it. Any loss to discount argument by husband is misplaced. He really needed to be arguing this stuff with the IRS. Wife also cited United States versus National Bank and also 6332. She only had two defenses when served with a levy. Anybody who's served with a levy only has two defenses. One, either she doesn't have possession or is obligated with respect to property or rights or property, or two, there is a prior written attachment. She simply can't argue these other things that husband wanted her to argue. This is a pay or be sanctioned statute. Under U.S. National Bank, a third party holding a property, acting as custodian, is not allowed to challenge the IRS on behalf of the taxpayer. If there was a discount issue, the IRS would have demanded that too. Wife did not have some kind of side deal going with the IRS. But even apart, well, let me back up a second. With all of this, there is only one way the calculation reconciles, and only one way wife can follow the levy, and that is that she pay the IRS what's being demanded, which is $320,331.13, the exact amount husband admitted to receiving in his pleading. But even apart from the supremacy clause, the trial court also erred without evidence. If we look at the ruling hearing, it's only 13 pages, and we can see from the get-go that the trial court is ruling in favor of wife on everything, up until the point where wife's or husband's counsel states she hadn't been paid because wife kept 100%. This is a brand new argument. The husband's counsel doesn't mention the discount, refers only to the house and fees alone, and falsely sends a signal to the trial court that wife still has possession of the money. There was no testimony, no affidavits, only unsworn attorney argument, which cannot stand. But again, no matter what the trial court believed, or no matter what the trial court was thinking, it failed to apply preemption. Regarding husband's supremacy clause arguments in his response, none are viable. I can't trace any of this to the record. And again, they weren't raised, so they constitute waiver. Next, the arguments are just plain wrong. The house cannot be levy exempt unless the taxpayer is living there. It has to be his principal residence. But the judgment of divorce shows that the husband gave up exclusive possession to the wife as of the date of the divorce. So there was months in there where he's not living there. It's not his residence. He can't claim the house as his personal residence. Next, husband claims wife was not obligated to pay husband anything at the time she was served. This is also false. The plain language of the judgment of divorce says that the obligation to pay husband 50% of the proceeds of the house and the attorney fees inured as early on March 3rd when the judgment of divorce was signed. In Phelps, future obligations are subject to the levy, not just cash. And in United States versus National City Bank, IRS can levy on contract rights, contingent rights, and unmatured obligations, whereas husband provides no case law that supports IRS can reach the house. Husband also materially misquotes the levy in his response on page 3, cites a section that applies to bank. Wife is not a bank. He also claims the law is too complex for the judge to understand, but I know of no doctrine that allows affirmance because the law is complex. And importantly, where in the world is husband's attorney arguing this stuff before the IRS? Federal law says he's the only one that can challenge the levy. He claimed he never received notice of the levy, notice of intent to levy. But there is testimony from a prior child support hearing that shows quite otherwise. And so he knew about this notice of levy before wife was served. And then there was 60 days wife was able to essentially delay the levy, giving him 90 days to do something or anything, and he did nothing. If husband's position is accepted, every taxpayer could just simply ignore a levy and then sue the custodian afterward, which is pretty much what husband did. As a final matter, the trial court was aware that husband had an opportunity to remove wife from the levy and make whatever challenges he wanted before the IRS while still preserving the cash. This was brought to the attention to the trial court for its waiver and estoppel effect. If husband believed wife was doing anything inappropriately, his counsel could have taken the money. The record shows that early in the litigation, wife offered husband's counsel all the money to place in her escrow under the proviso that the levy would follow her, that the levy would be removed from wife and put on husband's counsel. Not surprisingly, she refused. If there was any merit to husband's claims with all of this stuff, then there should have been no reason for him to take, for his counsel to accept the money. We respectfully ask this court to reverse the trial court's order and remand with instructions that the double payment be returned. Husband's attorney repay the $12,000 that she took, and husband repay the $28,331.13 that he took.
Thank you, counsel. You have
Thank
the
you.
balance of your time for rebuttal.
So initially, I would note for the panel that all $40,331 that the court ordered to be paid has now been paid to Mr. Festus and to his attorney. I do believe that that moots argument C from counsel, where he indicates that there was a problem with reforming the judgment for the path of payment, since that is now complete. I don't believe that this court can order any meaningful relief on that matter, and it should simply be mooted. With all due respect to counsel, this is really about what is the standard on a motion for relief from judgment? Because that's what they were asking for. The plain terms of the judgment are clear. She needed to pay husband directly $400,000 before May 31 of 2025 to receive the $50,000 discount. That did not happen. There were no provisions in this judgment for IRS levies, for acts of God, or for anything else that would have permitted non-payment.
So is your position that any judgment of divorce has to fully list that federal law, if there's binding authority that says, a tax lien is supreme on any of that, every judgment of divorce in the state has to have a clause that states that?
No, that's my point here is that the parties were all aware that there was a potential tax liability. As you look at the brief, what you see is there was hold harmless language that was not reciprocal in the party's JOD. So the wife received a hold harmless for both all debts, including specifically any IRS tax liabilities.
So what's your position then? What was the wife supposed to do when she gets these tax liens against her, served on her saying, hey, if you've got money to pay to husband, you've got to pay it to us. In federal law, she has to do that. Otherwise, she faces penalties. How is her paying that to the IRS not being held harmless? Isn't that couldn't you interpret that to being consistent with the indemnity clause of the settlement judgment?
We're not suggesting on appeal that the payments were improper, nor am I asking for the return of $330,000 to my client. Our position was simply this, that there was $430,000 owed for the business valuation. She made the first, or $450,000, she made the first payment of $120,000 in February of 2023. May 10th of 2025 came. She owed Mr. Festus $120,000 under the plain language of the judgment. That payment was never made.
So your position is just simply that she isn't entitled to the discount.
She's not entitled to the discount. And regardless of whether you think she's not entitled to the discount or whether the levy doesn't attach to the house, there's no evidence of that on the record. That part of the problem here is there was no actual hearing. So we have no one from the IRS saying this is what attaches to the levy, this one doesn't. When I look at the plain language of the levy, and with all due respect to counsel, that section applies to banks in the first part. And then the last section says for anyone else holding property for this person, which would suggest it applies to Ms. Ike in this matter. At the time that she was served with the levy, she was holding 120 that belonged to him that should have been paid on the 10th. She did owe him the rest of the business valuation in the future at some point in time. She made that payment to the IRS. At the moment that she was served with the levy, the house was still on the market. It was still unsold. She was holding some future proceeds that could at some point in time have been paid. Now, the fact in this case that a few days later, the house actually closed, but imagine a different situation where the house doesn't close for a year, for 18 months. Is she supposed to say, well, the levy, I got a levy in May of 2023. We're now here in May of 2024, and I now have to pay out, I now have to seek out the IRS and potentially pay out the levy.
What about the court's order to, if I understand it correctly, to have the wife pay $12,000 of the proceeds of the sale of the house directly to husband's attorney as opposed to the husband to avoid IRS, presumably to avoid IRS collection of that money? That the way I read the consent judgment of divorce, it says payment to husband, not payment to husband's attorney.
Judge, I don't know that there's any evidence on this record that she did that for any other reason than to ensure that the specific payment that was made for the attorney fees was actually made to counsel. I know he makes the insinuation, but that's not a part of the record, nor can we get into the judge's mind to see what the judge was thinking when she ordered that payment. Clearly, counsel had not been paid. I understand that, the counsel's argument that there was some, I guess, honor amongst thieves here, where the judge was going to help counsel get her money and, take the money from the IRS. There's no evidence of that in the record. It was simply the money was owed to the attorney. It should have been paid directly. basically taking a step out where you're going to say, oh, I need to pay Mr. Festus 40 and then he needs to turn around and pay his lawyer 12. I mean, the payment was always going to be split. It was mandated in the judgment to be split. So that's simply effectuating a term they'd already agreed to.
Gotcha.
But again, Judge, I think the standard of review here is important and that there are many possible outcomes here. The court potentially could have agreed with Ms. Ike and said, I'm going to hold the discount, or I'm going to find that the 41 is 40 and change is subject to the levy. She didn't do that. It's not outside that range of principled outcomes. Potentially both may have been principled, but where we're at now today is that she didn't grant her the discount. There is at least some insinuation in the record from Mr. Festus, and then, that potentially the wife was the one who called the IRS herself. Now, there's no testimony as to that. However, it is clearly insinuated. So it's possible that that was in her mind if we're making those kinds of guesses. I don't know, but the fact of the matter is that the order that was written suggests it's not subject to the levy. She didn't grant she didn't reform the judgment. The parties had contracted for something very clear, which was $400,000 to Mr. Festus prior to May 31. They effectuated the hold harmless, and she was given credit for all $320,000 in change that was paid to the IRS. There was still, without the discount, or whether the house was not subject to the levy, there is still some amount of money due and owing, whether that's 40 and change or whether that's 50. So there's multiple bases here to affirm on this record. And I think what the important part of it here is there's no fraud as against her. So, in order to reform a judgment like this, we either need fraud, mistake, illegality, or unconscionability. From the pleadings below, at no point is this standard actually stated. So I'm not quite sure what their argument was, except when you read it, eventually it becomes clear that it's fraud. There's no fraud as to Ms. Ike. The tax liability was known by everyone here. It's specifically provided for in the judgment. What's clear from the record too is they filed separate taxes during their marriage, or else this liability would have been joint and several. It's clearly several because they filed separately during their marriage. Everyone knew during this whole period of time that he had tax problems. Now, no one is relieved of kind of the unintended consequences of what happens here when the levy gets served. So and then to the panel, they do argue regarding the contempt here. One, in terms of the contempt, it's clearly indirect civil contempt. This is not a criminal contempt proceeding. There's no charging instrument. There's no documents. There's nothing. None of the procedural protections that a criminal contemptor would be afforded were done here. It's indirect civil contempt. She's ordered to make the payment. On some level, it's not even really clear whether this is just a motion to enforce the judgment, in that no penalties are imposed in this order. It just says pay what you owe.
How do you get the owing of the sales tax?
As I understand it from the record regarding the sales tax, is that my client attempted to turn in that sales tax form that's in the record to the State Department of Revenue. They said, you owe $2,700 because this transaction should have been marked as tax exempt. He went, as what you read in the record below is they went back to Ms. Ike and says, please remark the transaction as tax exempt, that he was unable, that she refused to do that. And that she said, no, it's his responsibility. But in the end here, again, this was a credibility determination.
But doesn't the agreement consent judgment also say that he's indemnifying her for all tax issues? And isn't that a tax issue?
Well, I think there is some indemnification. However, the transaction should be tax exempt. So it's
okay, but isn't that his problem, not her problem?
But I don't think he can, where he has to pay taxes that he shouldn't have to pay, because at least as I see it in the record, there is a refusal to fill out a form properly. That is no longer his problem. That is now her problem, because the transaction shouldn't be taxed at all. Now, you can argue whether it's tax exempt or there's zero taxes on it, but the State Department of Revenue, if you mark the form properly, it should be zero. Where he's not able to amend the form and only she can amend the form, she's now made it her problem.
But then, so did your client ask for an order asking her to amend the form?
That I don't recall that in the record, Judge.
I didn't either. That's why I'm asking.
So I guess they potentially could have filed a different show cause. I don't know, but either way, what was done was done. And frankly, she could go get the money back now too. It was a transaction that shouldn't have been taxed at all. There's-
Counsel, the one question I did have was, if we find that any one of these, there's a bunch of different buckets, right, of payments that were made, and people say, one side says 50,000 credit should apply, one side doesn't. There's sales tax on the car, there's a marital home, there's a tax debt. If this panel thinks that one of those issues was incorrectly decided, would you agree that remand is appropriate to allow the trial court to take that into consideration and then hear arguments on how the math should stack up?
I don't know that any one of them. I see the car as a separate issue because it's a separate transaction and it's not subject to it's not subject at all to the discount, which is really a matter of contract. So this, I guess I should say, is a matter that's specified in the judgment, whereas the car is essentially was a credibility determination between the parties. He said she didn't fill it out properly. She said he didn't fill it out properly. The judge made a credibility determination between the two of them and ordered her to repay the money that he shouldn't have had to incur. So I view that as separate from the tax issue.
Okay.
Which is certainly, which, well, I don't believe that we should be remanding it in either for that case. The court clearly had all the math in front of it. We're up here today, but the math was done multiple times. It was done in wife's initial motion. It was done in later motions in response. It was done in the motion for reconsideration. If you look at the motion for reconsideration on the record, the math is laid out exactly as everyone describes it. Everyone knew what the math was. The question was, under 2.612, is there a basis to modify this judgment of divorce? Where everyone had agreed to it, it's a contract. The court found the answer was no. That is clearly within our range of principled outcomes in this case.
Any further questions?
So, yeah, I do. So, okay, so you say that issue is just a credibility contest, meaning there's no exhibits that were entered in the case that would show definitively which party was correct, right?
The only exhibit that is entered in the case is the actual transfer form itself, where it's not marked as a tax exempt, but the otherwise, the question was who could mark it? Husband's position was only she could. Her position was she could have, as well as I read the record. So that's the only exhibit that's relevant
Had
to
a
this.
signature line for her.
It did have her signature on it.
So he would have to, he basically would have to fraudulently edit the document in order to add or subtract anything from it.
As I understand
Since
it,
it's attested to by whoever signed it, right?
I believe it is attested to. It is a part of the record, and it was attached to the motion for the show cause on that issue.
Any other questions?
Thank you.
All set. All right, counsel, you have some time left for rebuttal.
Can you start with that last issue? Did she fill out the form correctly?
She filled out her forms correctly. If you look at the record, the form that counsel is referring to is the form that husband fills out. And husband is the one who signs it. It says right on there that it's his responsibility to sign it. And he's the one who left the exemption box blank. There was a form before that wife submitted. I don't think it's on the record, but the wife submitted a form that showed the sales price or the market value, whichever was less, in accordance with Michigan law.
Yeah, so when there's a vehicle transfer, both parties have to sign the same form.
I'm thinking that
There's a portion for seller and there's a portion for buyer on the title.
yeah, so because of the animosity between the parties, it was probably signed and then delivered.
So we don't know.
We don't
Is that
know.
in the record?
It is not.
Okay.
Not that I
Well, the only form that's in the record is the IRS form that was submitted. Who signed that form?
Well, it is a state of Michigan, with all due respect, it's a state of Michigan form.
Oh, state of Michigan. Sorry,
Yes.
right.
And it is supposed to be signed by husband. In fact, I think I highlighted the form in yellow that shows the areas that were most relevant.
Anything else on that issue?
Oh, thank you.
With regard to the payment wife has already made, she's already paid the $40,331.13 a second time. And of that includes the $12,000. She paid this under threat of jail, and I think there's still an issue because the trial court exceeded its authority because it essentially rewrote the judgment on divorce. But in the whole scheme of things, that's not really what this appeal is about. I thought that counsel, with all due respect, glossed over the status quo order. The status quo order preserved the discount, and it was open-ended. It was until further order of the court. And again, further order does not vacate the status or the discount. The judgment hold harmless. That is something that it was wife was aware of the tax liability, but she did not know the extent of it. And the record shows that husband was concealing this from her. IRS will not submit to state courts. I tried to get the IRS agent to come in and give testimony, and she quickly got general counsel, I think his name was Heitmeyer, who supplied me with all kinds of authority that would squash any kind of subpoena, so we didn't go there. But the levy does remain in effect until it's released. So if the house did not close, then there would be another sale and another closing, and the levy would remain in effect until the house closed. The IRS was on wife like an ink on paper, and I think that the record is clear that that the house is subject to the levy. Also, at least from the IRS's point of view, and if husband had any kind of arguments, only he is the one who can challenge the levy under federal law. Wife cannot fight on his behalf.
Counsel, just so we're not covering ground you already covered in your primary argument, is there anything else that that brother counsel raised that you need to
Yes,
specifically address?
Reformation was not the only thing before the trial court. There was an amendment to the motion that provided for the supremacy clause and relief under the supremacy clause. That's all I have.
Anything else? Any questions for counsel?
Oh, thank you.
All right. Thank you very much for
Thank you.
very interesting case and well briefed and well argued. Case number 6 is submitted. All right. Excellent. Let's recall going back to item number case number 372003, People of Michigan v. Rudy McFall. Mr. Tomac. State your appearance for the record, and you may proceed with your argument thereafter.
Good morning, judges. My name is Robert Tomac. I represent the appellant Rudy Ashton McFall. We are alleging that the trial attorney was ineffective for not calling Mr. McFall to the witness stand. There was a unique set of facts here. The defense was arguing strenuously or for a instruction for self-defense, and at that point the counsel indicated they were going to put he was going to put Mr. McFall on the stand. And just at the very last minute, apparently just the night before, the judge advised the attorneys that he was going to give the self-defense instruction, and so we're saying the mistake is right at that point. The attorney didn't have much time to talk to his client, just a few minutes apparently before the jury's called in, and decides not to put him on because he's got an instruction there. But the problem with that is that there was scant evidence of self-defense. I mean, I think the judge realized that, and maybe that's why he had to think about it. And he said he conferred with his colleagues. And so the thing to do would have been to still put him on because the self-defense, really couldn't be made out without without his testimony to indicating what he felt or how fearful he was, or, what his state of mind was. So, and now I know that we run up against the, rule that, if a if a defendant acquiesces in his attorney's decision not to testify, then it's waived. We we submit that this was not that there just wasn't enough time for this Mr. McFall to consider his situation. That this wasn't really a knowing and intelligently given decision.
So your primary argument is it that there wasn't sufficient time between appointed counsel and to talk to his client before waiving his right to go on the bench?
Well, that works into our claim that the attorney was ineffective in that regard. When the judge said that he was going to put in the self-defense instruction, it seems like it was a knee-jerk reaction on the part of the attorney to say, okay, well, then we're not going to testify because that'll be enough. So we're just saying that that decision caused a outcome that was, to Mr. McFall's disadvantage. And so that's our argument, not just that there wasn't
Matt,
enough time.
Why is that not a reasonably strategic decision by the trial counsel? How does that fall below the standard of reasonable conduct?
Well, I guess we have to, I know that there's the presumption that such decisions are part of trial strategy. We're pointing to the unique fact pattern here that, like, for example, if the attorney had adequate time to consider this preparation of trial and decided not to call him for various reasons because he's going to be cross-examined or whatever, then easily that's strategic move. But here we know that this is a rush job, that there just wasn't enough time for the informed decision about whether or not he should be called, because right away the judge said, okay, we'll bring in the jury. So we're just talking about a matter of minutes here.
Wasn't there evidence though introduced in testimony that actually did support, or at least a jury could find self-defense? There was evidence that the victim had threatened defendant. There was evidence asked for a gun during the fight.
Yes, what I'm saying is I would say there was very little. I mean, there was nothing. Of course, there was nothing like what the Mr. McFall was feeling at the time, how he perceived the situation. There was some, and that's why the judge. But the fact that the judge had to really consider it and confer with his colleagues, I mean, tells you that it wasn't. He even said, "Where I'm going to err on the side of caution." So there was very little evidence of self-defense. Thank you.
Any other questions?
Thank you.
All right, case number one, item number 1372003 is submitted. Okay, we're gonna take a short recess before we continue with the 10 a.m. call. Thank you, everyone. We will proceed with our 10 a.m. call with item number 6, case number 37298 Oh, we called that one. I apologize. That was our last one. I didn't have it checked off. That case is submitted. Item number 7. Case number 371-199. Nicholas Tate v. John Walker.
Val Washington appearing on behalf of the appellant.
Mr. Washington, good to
Judge,
see you, sir.
likewise, congratulations.
Thank you. Thank you.
May it please the court, Val Washington appearing on behalf, I'm sorry, Mr. Goldstein, do you want to put your appearance? Well, I don't want to put your appearance on the record.
We'll take your appearance now or later, whatever you prefer. All right.
Robert Goldstein on behalf of defendant Mr. Walker.
I know the court has read the materials. I can tell by the questioning that you've given to earlier appellants and appellees. Do you have any questions for me before I begin?
Any questions? Any questions? Mr. Washington, let me just make sure, I'm trying to make sure to frame these issues correctly.
Sure.
And make sure that we're on the same page. Would you agree that this is, we look at this, we should be looking at this case under a premises liability theory?
Yes.
Okay, so that we're correct on that.
Yes.
And that you'd also agree that under Michigan law, defendant has no duty to protect against unforeseeable harms.
That's correct.
And that's correct. And so here we're talking about whether or not the injury that arose, whether that was foreseeable. That's really the heart of what we've got here. Is that right?
No, I don't agree with that, Judge.
Okay.
The reason I don't agree with it is that the law, as I understand of premises liability, is that the possessor of the land has a non-delegable duty to an invitee to remove known dangers and to warn if you can't remove the danger. In this case, Mr. Walker was the person who created the issue. He's the one who connected the RV, his RV, not the joint RV, or not Mr. Tate's RV, but the RV that belonged to him, connected its electric service through the extension cords into the house's electric service. And that's what caused the pathway for the electricity, 4,800 volts of electricity that came from the down DTE wire on top of the RV into the home.
But did I understand the record correctly that your expert, Brent McKinney, said the setup before the line fell as a quote, safe electrical condition?
It was a safe electrical condition. We are not contending that the connection was the issue. What we're contending is the negligence, is failure to disconnect and unplug, which Mr. Walker acknowledged was his plan to do after finishing his cleaning of the RV.
So once the storm came up, he had a duty to unplug. Is that your position?
No,
or
sir.
Explain it to me.
The cleaning occurred on the 14th of November.
Okay.
The storm was on the 15th of November. He had ample opportunity when he finished cleaning, that his deposition testimony was, I finished my cleaning and I forgot to unplug the extension cord.
Well, let's say he didn't finish the cleaning. He decided to go play a round of golf and did the cleaning on the 15th. What's the issue then?
Well, it's a hypothetical, but because those aren't the facts. The facts are, he said he finished the cleaning on the 14th, didn't unplug the extension cord, and that's what carried the electricity into the house.
Mr. Washington, even under a premises liability theory, don't you have to show proximate causation that the harm was foreseeable?
Well, the harm was foreseeable because he knew from the year before when the wire came down and almost burned down the garage. They had the event testified to, it was, I believe, July 19th of 21, of 19. That's when the wire came down and it hit the fence. And Mr. Walker's testimony was almost burned down my garage. So he knew that it was foreseeable that the wire came down. This was an area, it's a rural area. They knew, and where he parked the RV was directly under the wire, the overhead wire, that DT ran through their backyard.
But wouldn't you, foreseeability, just because a power line fell one time in your yard, you'd have to foresee, aren't you asking us to assume that foreseeability, that he'd have to foresee a windstorm would come through, foresee that it would fall in the garage, foresee that it would charge the house, foresee that a guest, an invitee would see it sparking, that the guest or invitee would leave the safety of the house during a windstorm and go and unplug it?
He didn't do that, Judge.
Okay, explain that to me.
They were in the house, the wire came down, current came into the house, and there was sparking at the point of the plug being placed into the wall socket
Yeah.
In the house.
in the house.
In the house.
The sparking stopped, but the first thing my client did was to turn off the power. They thought it was a power connected issue. So he turned off the power. The sparking stopped, but it was still smoking. He grabbed the wire, pulled it out of it because they were concerned about fire in the home, and started to wind it to get it out of the house. Those are the facts in terms of what my client did. But here's the point. Our position is that once the duty, the undelegable duty, as it relates to protecting against a known condition, a dangerous condition, arises, it's a factual
But what was
question.
the known dangerous condition?
That the wire would come down and the electricity would be in a highly charged overhead wire.
Isn't that the same risk that every homeowner has, that a power line can come down?
I don't know about every homeowner. I don't know the answer to that question, Judge. All I can tell you is that in this area, the way the wires were strung, this was something that had happened before, and it was not unforeseeable that if you leave the motor home plugged into the house service during a windstorm, it's not an electrical storm, it's a windstorm. They've had the windstorm and they'd had the wire fall before. The other,
I guess what I struggle with is unforeseeability. There are hundreds of thousands of different ways a power line could come down and cause a dangerous condition on property. Why is it foreseeable that him leaving a power cord is one of those?
the power cord itself isn't the dangerous condition.
Okay.
It's the failure to break the connection that we're saying was the condition. The pathway into the house was secured because it wasn't one power cord. It wasn't one extension cord. It was 3 extension cords that were all daisy chained together from the RV into the house. And we're saying that when Mr. Walker says, I forgot to unplug the extension cords, I meant to do it. To me, that shows me, or shows anyone objectively looking at it, that he intended to break that connection. He didn't do that.
That he knew that it would be dangerous not to do that.
Exactly. That's the difference here. It's not that he made the connection. That's what Brother Counsel is going to argue. It's the fact that he knew that the connection ought to have been disconnected when he finished, and he didn't do that. By his testimony, not mine. And this was in response to the question from his lawyer. Page 69 to 70 of his deposition, he says, I meant to do it. It's my fault. So when you talk about foreseeability, he knew that it was dangerous to leave it plugged in, or presumed that he knew it was dangerous. Again, factual issues that need to be resolved by a jury, not the judge. So when you talk about what happened here, Mr. Tate was injured by the shock that was carried through the 3 extension cords into the house that impacted him.
Is it? Go ahead. No, go ahead.
We can agree, though, that a layperson testifying in a deposition is not necessarily responsible for making a legal conclusion. So if somebody says, I'm liable or I'm at fault, they're not a lawyer. That's not necessarily dispositive, right?
I agree with that. I absolutely agree with that. But it does then create a question of fact for the fact finder. And that's what was taken away from us by the judge's decision.
Well, is your position that foreseeability is that a issue of law, or is that an issue of fact?
Well, it is a legal decision that has to be made by the court. That's the
Okay.
question. But
And let me ask a second part of that. I'm
Sure.
sorry to cut you off,
No,
Mr.
you're fine.
Washington, but the
Mhm.
second part of that is you keep saying your guy knew, or that defendant knew to unplug it and should know because of the prior storm. Is that the test, or is the test what a reasonable person?
Well,
That a reasonable person, an objective sort of reasonable person versus this individual's unique knowledge of this area? What's the test?
test is what would a reasonable person do under the circumstances? The question becomes, what Mr. Walker did, was it reasonable or not? Again, it's something for the fact finder to determine as opposed to the court. That's not the legal standard that the court has to determine at that point. It's for the fact finder. Once the duty arises, then everything else that flows from that, it becomes part of the analysis, and that can be taken into account by the fact finder.
But you agree foreseeability is a matter of law.
I do.
Okay.
Sure. And I also note that, remember, we had the res ipsa loquitur count in our pleadings. We only had two counts here, res ipsa and premises liability. And the Pugno versus Blue Harvest panel clearly says that res ipsa applies in a premises liability case. That was completely ignored by the trial court. Absolutely not mentioned one time in that opinion and order. And that's part of what, if you want to talk about the issue of foreseeability, the standard as it relates to res ipsa is that it's generally, the event must be of a kind which ordinarily does not occur in the absence of someone's negligence. 2, it must be caused by an agency or instrumentality within the exclusive control of the defendant. Mr. Walker. Court did not address the res ipsa argument at all, and just then moved strictly to the issue saying that there was no notice, there was no question, the fact that there was no notice, and the Pugno case clearly states that if the possessor of the land or an agent creates the dangerous condition, then notice is imputed to the defendant. And that's what happened here. And the Pugno case involved the pallets that were stacked, and then they fell over on the repairman and injured that person. And you've had, multiple examples of where it's required that there be this duty, case of a dog bite, case of the oil on the water, case of a chain across a checkout at the grocery store. These are things that have been determined are factual determinations as opposed to legal determinations. I didn't reserve my time at the end. I'd like to reserve like 5 minutes.
You've got time, Mr. Washington. Any questions? No, thank you.
I'll end and I'll come back to you after brother counsel.
Yep.
Thank you.
You've got time.
Good morning, Your Honors. I think the question hit it on the head, is foreseeability. There's no duty without foreseeability. That's the whole point of my argument. In fact, in the trial court, what I cited, I didn't cite it here, but the law school case of Paul's graph and that whole event that took place there. And I said, this is a Paul's graph case. Nobody could have imagined it happening again, but it did. And this is Paul's graph. And the whole point of Paul's graph was there was no foreseeability or duty imposing event. And that's what we have here. Everybody agree. Let's just start off with this. All the parties agree this wasn't foreseeable. But we have the deposition testimony that we cited. All the experts agree this wasn't foreseeable. They even say, as Judge Bilcock referenced, this was a safe condition. Having the extension cord was a safe condition. So fundamentally, we have a problem here with any premises case.
Having 3 extension cords hooked up to one another and then plugged into the house, in the inside of the house, that was a safe condition.
That's what they said. And well, I mean, that's the point of an extension cord, though, is Your Honor.
No, you're not supposed to hook them up together.
Yes, you are.
It
That's
actually
the whole-
specifically often says that if you actually read the warnings, you're not supposed to hook one extension cord up to another one.
Well, no, but I don't, first of all, that wasn't an issue in the case because the experts agreed that the alignment of extension cords was a safe condition. And there was no mention of it being improper in any way. In fact, that's a plaintiff's expert agreed with that. So we have that. So there's not a dangerous condition to begin with here to prompt any sort of duty imposing obligation to my client, Mr. Walker. And that's fundamentally what's absent in this case. And I think what he's Mr. Washington is saying is that I guess by keeping it plugged into the house, that created this unsafe condition. But the condition was the same as it was before when this event happened. It was still a safe condition. There's an intervening unforeseeable event that occurred with a thunderstorm causing a power line that we had no control over falling down in the middle of the storm. Now, this would have been, what if this had been where Mr. Walker parked a vehicle, or even Mr. Tate parked his vehicle on the premises, the line comes down and they don't know that the line came down and electrified the area. And one of them goes into that car and becomes electrocuted when he touches the car. How's that any different than having a power line or an extension cord out there that's poses a safe condition? It's no different than having
It depends on whether you're talking about foreseeability or duty and breach. I mean, arguably, you could argue that by hooking up the extension cords and sticking it inside of the house, you've created a potential dangerous condition, but that's not the same thing as saying it's foreseeable that there's going to be a storm and that the power line's going to come down and it's going to fall on the RV and then it's going to charge up the extension cord and it's going to set fire to the house or create electricity in the house. Those are two totally different things.
Well, I guess I'm not, Your Honor, well, I'm not sure what the question, having it plugged into the house, that's what happens with the extension cord in any event. And you can power outside of the house by plugging it into an outlet. Even it could have been an outlet outside too. So I guess I'm not sure. The other things you were talking about were the unforeseeable events with a power storm, where the thunderstorm knocking down a power line onto this extension cord that was otherwise safe condition.
I'm just saying that's the difference between a power line falling onto a vehicle in the driveway, and that's the only thing that happens. Like you say, there's no breach there. Nobody's breached a duty of due care. Arguably, this isn't that. Arguably, this would be you've created a potentially dangerous condition by actually extending that cord all the way into the house. But again, once again, that has nothing to do with whether or not the ultimate injury here is foreseeable.
Yeah, so yes, I agree. This is not foreseeable in the end. And that's the whole point of this.
Counsel, if I can just change directions briefly, could you address, and I know Mr. Washington didn't bring it up, but it was briefed, this issue about there was no support, there wasn't sufficient evidence before the court to support the motion?
Well, first of all, it really came down to whether there was any duty in the first place in this case. All the evidence was before the court as to what would have formed duty here. We all know what happened. We all know what happened in this case. That's why res ipsa wasn't even applicable. Res ipsa only comes into play when you don't know what happened in a situation that otherwise only happens if there's some kind of negligence. That's not, and that to explain the negligence, it could otherwise be explained. Here we know what the factual events were that led to the situation we have today. So the court had all the information it needed to see if there was, in fact, in the first place, which is and it's an issue of law, whether there's a duty in the first place. And again, the whole issue of whether there's a duty, if there's some condition that creates a duty on the premises, comes down to foreseeability in the end. Again, that's what we have. Even though poor Mrs. Paulsgraf was injured in a similar kind of situation.
Well, it doesn't though. The foreseeability issue is a proximate cause issue, as Judge Patel noted when we began. It doesn't have anything to do with duty, and that was clarified in Candle El Sayed. Foreseeability is proximate cause. We were operating under a different law for a long time with Lugo, where duty actually didn't exist if the danger was open and obvious, but that's over with now. So foreseeability is a proximate cause issue. It's not a duty issue.
I believe it goes to both issues. In order to have a duty, you would have to have foreseeability of.
In order to have a duty under premises liability, you have to have possession and control of the land, period. And then at that point in time, you owe all the invitees a certain duty and licensees a certain duty.
Well, I'm going to quote from a case, one of the cases that I said in my brief about the duty of an invitee, which for our purposes today, we're considering Mr. Tate an invitee. I'm citing a case on page 16 of my brief, State of Livings versus Sage Investment Group, which says, this is a quote, possessor of land owes an invitee the duty to use reasonable care to protect the invitee from an unreasonable risk of harm posed by a condition on the premises. The condition on the premises that we're talking about today is the extension cord. Again, I get back to what everybody has said in this, including the experts. This was a safe condition on the premises when the storm came through and knocked down the power line. So if we're going to look at it, and I think without foreseeability, you can't impose a duty. But even so, let's say there was a duty, there was no breach here of any type of duty because, again, this was unforeseeable. And even their own expert said, and I'll quote from Mr. McKinney's report, which I found interesting. And Mr. McKinney, Brent McKinney, was plaintiff's electrical expert. Mr. Tate, this is the factual predicate to in his report. Mr. Tate then began winding up the cord. Unfortunately, and this is the key word, unknown high voltage remained on the exterior metal bars on the plug end of the extension cord. And right there, their own expert says this was unforeseeable and unknown. So if I don't know there's a danger there, or should have reasonably known that there was a danger there, how have I breached any duty, or how do I have any duty in the first place? That's really my argument.
Was there anything in the deposition of your client where he explained why he meant to unplug the RV?
I think, and again, this is from my recall, but I think it was the reason he was going to unplug it. He just wanted to store it. That's all.
He was done charging.
He was
the
done,
RV.
yeah. And whatever he was, I think it was actually used to charge things in the RV as well. And so I think he was just done with it at that point.
Any other questions?
Thank you.
Thank you.
Any other questions?
Thank you.
Thank you, counsel. Mr. Washington?
Briefly, our position is that when Mr. Walker concluded his cleaning operation, whatever it was, all he had to do, as he said, was to unplug the extension cords. He didn't have one wire going from the RV into the home. He had 3 extension cords daisy chained together. He says, I meant to unplug it. He didn't unplug it. It carried the voltage into the home, causing the injury.
Did he say why he meant to unplug it?
He was done cleaning. He plugged it in so that he would have power to the RV to clean on the 14th.
So there's nothing in the record where he says, oh, yeah, I meant to unplug that because it's dangerous to leave it like that. Right?
No, we wouldn't be here, Judge, if that was the case, but no, nothing in the record like that. But that's why we want the opportunity to expand the record and go back for the factual issues as it relates to trial.
So do you agree with counsel? He said your client's expert said that it was perfectly safe to have these 3 extension cords tied together and then plugged into the inside of the house.
No, I don't agree with that. Any other questions?
But you did, I think earlier though, just to clarify that point for oral argument is the record is correct that Brent McKinney described the setup before the line fell as, quote, a safe electrical condition.
I don't disagree with what's in his report in terms of how he's describing it, but he then goes on to say the issue became failing to unplug it, which provided a pathway for the voltage into the
Right.
home.
But the setup originally, he's out there cleaning and but for the windstorm and the power line coming down, there weren't issues with it. He could clean it, use it to charge it. You know, my in-laws in the summer, they park their RV out in front of their cottage and it's plugged in all summer.
Sure.
Right?
That's the condition itself was created that way, but leaving it that way created the unsafe condition that should have been, rectified.
Yeah, I understand your position. I just want to clarify that point. Anything else, judges? All right. Thank you,
Will.
counsel. Good to see you, Mr. Washington.
Likewise, Jeff.
Thank you. Have a good day.
Don't ask, especially this morning after Thanksgiving break. Oh, my goodness. That case is submitted. Calling item number 8, case number 372434, Mathea v. Young. Counsel, please approach. Good. Please put your appearances on the record.
Good morning. John Cospang on behalf of plaintiff appellant Euphrates Mathia.
Counsel, proceed.
I would like 5 minutes for rebuttal.
Okay.
In this case, the trial court did a really poor job of making a clear record of its decision. It only told the parties that the motion was granted. And so informing the questions presented, we're left to Auto Club's arguments. And their argument was primarily this, that Mr. Young, the negligent driver, was not served and was dismissed so that Euphrates Mathia could not establish fault. This position is premised on the idea that Mr. Young is a necessary party to the uninsured motorist claim. However, and that's the first question, is whether Mr. Young is a necessary party. And the answer is no. Auto Club's counsel during oral arguments stated that uninsured motorist claims is a tort-based claims. And under MCL 62957, it allows the trier of fact to apportion fault, whether or not that tortfeasor is a party or could be a party to the action. Further, this issue is governed by the policy language because it's an uninsured motorist claim, a claim where the contract rules, and there's 4 elements in that contract in order for an insured to recover. The only element in dispute is whether plaintiff is legally entitled to recover from the uninsured motorist. And this court and courts have routinely interpreted legally entitled to recover simply means that the plaintiff must be able to establish fault.
Counsel, am I correct that under Michigan law, had the insurer wanted to make it a requirement that the driver be a party to the case, that Michigan law upholds those types of contracts? Is that correct? If you don't know, that's fine.
Yeah, I'm not sure, Your Honor, but I do believe that uninsured and underinsured and uninsured motors, if that was the case, I think that it would be an illusory contract because most of the times these types of situation kicks in when there's a hit and run driver, and having an unknown driver would make that contract illusory. The second, so this leads to the second question of whether or not.
It doesn't really matter anyway, right? Because there's no name and retained provision in this contract anyway, right?
Correct. The second question is whether or not plaintiff could establish fault on Mr. Young's part. And the answer is yes, because MCL 257-402 creates a presumption of fault when it's a rear end collision. And that's exactly the type of collision that occurred here.
Was there any evidence in this case rebutting that presumption? Again, any evidence that the person was an epileptic or that they passed out due to no fault of their own or anything like that?
No, Your Honor. So Miss Mathia did provide deposition testimony where she talked to the other driver, and the other driver, Mr. Young, admitted to being distracted. The plaintiff could establish fault. I think I just want to address Auto Club's rebuttal in that their rebuttal is that because the trial court asked plaintiff to dismiss the case, plaintiff then voluntarily dismissed Mr. Young from the action. That's when the court granted leave through. Auto Club Auto Club filed their motion for summary disposition. The trial court denied it. They filed a motion for reconsideration, and then the court permitted the motion. And their basis is that under MCR 2.102E, or excuse me, under 2.504 A1A, the second dismissal acts as a dismissal on the merits with prejudice. But Auto Club also did not address the fact that 2.102E, when a defendant is not served before the summons expires, it is automatically dismissed. That defendant is automatically dismissed. And the court rules provide that even if the clerk does not enter the dismissal, and if notice of the dismissal is also not tendered, it does not affect the dismissal.
It's
So
a dismissal by operation of law, right?
that's correct. And it's automatic. So even if the trial court or when the trial court asked plaintiff to dismiss Mr. Young, and when plaintiff actually did dismiss Mr. Young, it was to no effect because Mr. Young was not a party capable of being dismissed at that time.
Because the court didn't have jurisdiction?
Because Mr. Young was already dismissed.
Yeah, the court didn't have jurisdiction over his person.
That's correct.
Okay.
If there's-
Any questions? Any further questions? You have time for rebuttal.
Rebuttal. Sarah Nadeau, on behalf of Defendant Auto Club. I rest on my briefs, Your Honor. I really don't know what else to say. I haven't learned anything new in the months since we briefed this. You know the issues. The decision to grant summary disposition is, the reasons behind that are a question for all of us. I don't know what Judge Gillis was thinking. I would just perhaps say that I don't believe that decision was based on any of the facts as far as establishing fault or not establishing fault. I think it was based more on procedure and whether or not the process had been followed properly.
So would you agree? So let's just make sure we agree that what the rules mean, right? That when the summons is expired by operational law, the individual is dismissed, correct?
According to the court rules, yes.
And the case law
And
interpreting.
that court rule wasn't fully fleshed out again in the circuit court. None of these things were argued there. You have my waiver argument. However, I
Right.
recognize there's an unpublished decision Judge Wallace is very familiar with. And while unpublished decisions are not binding, they are persuasive. And so, yes, I have very little else to add.
Thank you, counsel. We understand the position you're in.
All right. Thank you, Your Honors.
Thank you.
Thank you. That case is submitted.
Thank you. Have a good day.
Any objections to continuing on? Okay. Any objection to just continuing on? All right. With that, that concludes the 10 o'clock panel. And we're now moving on to the 11 o'clock panel. So I'll note only 55 minutes behind schedule,
Okay.
according to these call sheets. With that, let's call item number 9, case 374-578 Henderson v. State Farm Mutual Auto. Counsel, you may approach. We've got folks. We got at least one. There we go. Counsel, please state your appearances for the record.
Morning, Your Honor. Andrew Mahalich appearing on behalf of the plaintiffs appellants, Stanley and Diane Henderson.
Thank you. Counsel for the appellant, you may proceed.
Initially, I would like to reserve a few minutes for purposes of rebuttal. This case arises from an automobile accident that occurred on June 6, 2022 in Ferndale, Michigan, where the individual defendant Cameron Wright, hit and drove over my client Diane Henderson was a pedestrian. Mrs. Henderson was left severely disabled. She's undergone more than 50 surgeries. She came very close to dying. They almost, family had to make a very difficult decision. And so far, she's incurred over 1.6 million medical expenses. The central issue on appeal deals with vicarious liability and whether Mr. Wright's employer, KMAX, is vicariously liable, that is whether Mr. Wright was acting within the scope of his employment. The trial court, in granting summary disposition to KMAX, focused on whether the purpose of his driving at the time he hit Mrs. Henderson was for the employer. We believe that the issue, and it's something that's evolved, I believe, particularly post-COVID, and given the realities of remote work, and in particular, Mr. Cameron Wright's individual responsibilities. But the real question is not whether he was driving for work, but rather he was working while driving.
Okay, so counsel, let me just make sure we're on the same page on a few things regarding that issue, which is you would agree and admit that KMAX had a policy that prohibited use of a cell phone while driving. Is that correct?
There was a policy, but what actually occurred and what he testified to what he did.
Right. But I just want, there was a policy. We agree with that.
There was a
Whether or
policy.
not it was followed or not, but there was a policy. And then the next question is that he was on a personal errand. That was the purpose of his trip, what he did during that trip, but we're on the same page that his purpose was to go get his dry cleaning, right?
His stated purpose was, and that wasn't corroborated. The timeline doesn't match. And the reason he acknowledged he was going was to get work clothes, and admitted that they weren't personal clothes. There was nothing happening. He was
When you say
clothes.
work clothes, were they mandatory? Was it a mandatory uniform that KMAX required him to wear?
It was not a mandatory uniform, but it was collared shirts, polos. It was what he
Did
acknowledged.
they reimburse him for those costs of those clothes? Or did he buy them with his personal funds?
I don't know the answer to that. It's not something, but I would expect. I didn't see anything that said that he reimbursed them. And the vehicle, however, that he was driving was reimbursed. I think that the testimony that was introduced by not only Mr. Wright himself, but also his direct supervisor, Mr. Mahaffey, who also testified in the capacity as the corporate representative for KVAX, indicated that this is in a post-COVID type reality. He was a remote employee. He reported to work twice a week. He worked remotely. When asked what his responsibilities were, it was to answer emails, monitor his phone, respond to phone calls, and send text messages.
And so,
that's what his job was.
right, but I understand that you did have the records from his business phone that showed a timeline of all texts received and sent and a phone list or
No.
phone calls.
No, we had phone calls. The text messages were never delivered, and that's the second part of our appeal, is that we asked for a forensic that Mr. Wright himself didn't have any phone calls, text messages, emails, anything from his personal phone. We asked for them with respect to the company phone, and the company phone, they said they weren't available.
So let me just pause you for 1 second. So you did get his personal phone.
No, nothing.
So during discovery, you got no records from his personal cell phone.
Nothing. He said that they weren't available. That was ordered by the court, and we didn't get anything. Nothing
But he
was
said it
returned.
was unavailable. So you followed that.
Well,
and-
But we also asked, and the technology again today is readily available. It takes about 10 minutes. We asked if he had the phone. A forensics examination of the phone would have revealed all of it. It's in there. Whether we, as a reality like that or not.
Is that part of your appeal though? That issue is the way I read. Okay, because the way I read it, and if you could point me to where that is in the record, because the way I read it, the issue was really over the KMAX provided cell phone as opposed to his personal cell phone that was on appeal.
Section 3, the circuit court erred in denying plaintiff's motion for more completing its resign, September 11, 2024. Does that give you what you're talking about?
I think so. It was part of the order that Judge Rowe denied, that we asked for his a forensic examination of his phone. The point being that Mr. Mahaffey, his direct supervisor and the corporate representative, testified that this position, Mr. Wright was had the title of an account manager and sales engineer. His responsibilities were defined as acting as a liaison and acting as coordinating and taking calls from customers, and then coordinating it with staff in terms of making sure. On this day, the testimony shows that there was a serious issue with the, and we saw that with emails, even though they were substantially redacted, with Ford Mexico. That week in Michigan, it's 2 days after July 6th. It was 2 days after the 4th of July holiday. Not a lot was going on, but in Ford Mexico, they don't celebrate the 4th of July. Ford Mexico had gotten a bad part. It was a defective part, and it was shutting down their assembly line. It would cost millions of dollars a day for that assembly line to be shut. What was being coordinated and the unusual amount of activity that day, and what was the topic of the email that he responded to after he left the home. It came in after he left, before he hit Mrs. Henderson. And while he was on the accident scene, he responded, all before getting to the supposed purported dry cleaning that he came up with, that's frankly uncorroborated, other than he did 24 minutes after the fact, after he left the scene. Somehow it then showed up. But putting that aside, there was a hot part. There was communication with customer relations. There was at KMAX. This was a big deal. They had communications with part manufacturer vendor to get new parts made.
Right, Counsel. Let me ask you this: is do you agree that the issue of whether he was acting within the scope of his employment or not, that's an issue of law for the court to decide?
Not in this circumstance, where we have shown that in fact he was undertaking responsibilities during the course of this while he was in the car.
Wait, was one of his job responsibilities with KMAX that he would have to do some travel?
It was.
And what kind of travel?
Well, he would travel not only to customers, but he would travel to the office. He would, it was essentially to accommodate the fact that he was a remote employee.
Okay, so now would he get reimbursed for his mileage for that travel?
He received a monthly stipend.
Oh, a stipend, just a general stipend.
Yes, he received a monthly stipend for that, for the use of his car that was anticipated during the course of a month.
That was a flat rate every month, right?
It was. What he did is, Mr. Mahaffey testified that his responsibilities were to monitor that company phone, to answer emails, text messages, telephone calls throughout the course of the day. That's it. Okay, this isn't a situation where I'm suggesting that on some blatant base or some overall basis that if you have a company phone, you automatically are responsible. He had a personal phone because he wasn't allowed to use the company phone for personal business. His wife testified that he, in fact, when they went out to dinner, when he wasn't working after 5 o'clock or when he stopped, he didn't take his company phone with him. He would take it with him on vacation. He would take it with him when he was working and he was responsible. KMAX was aware that that's the job duties they gave him. When I questioned Mr. Wright in his deposition, I said, what did you do after the accident? He said, I kept working. He didn't say, well, I started working again. And that may be, semantics, but he said, I kept working. When I asked him, whether he had abandoned his responsibilities during the course of the day, during that drive, when he went and during the drive.
What window of time are we talking about? Are you alleging you're saying he got up at, I don't know, 7 o'clock in the morning. Let's say he wakes up at 7. He's on the clock until he falls asleep?
No. But in this circumstance, he's working. The defendant's counsel suggested he did this on his lunch break. That's not what the testimony says. Testimony is that he ate lunch with his wife, and his wife corroborated that before he left the house. If there was no need for a company phone, if he didn't expect, that you would work from your car, work from wherever you are, he would have no need for a company phone. He had a company laptop. He worked from home in a landline, that he would take calls, Zoom or otherwise there. Why did he have a company phone? Why did he bring it with him? Well, it's in accordance as part of his job. And again, Mr. Wright testified that he never abandoned responsibility during the drive to his employer.
Well, let me ask you this. So you're saying that if, let's say he left his home to go work at Starbucks, right? So he took his phone with him, took his laptop with him, went to go work at Starbucks for the afternoon. Accident happens from his house to the Starbucks. He's not required to work at Starbucks, but he chose to do that. His employer's not requiring him to work at Starbucks. During that time, is that for the benefit of him? Because it's more convenient for him to work at Starbucks, or is it for the benefit of his employer? Isn't that part of the equation we have to look at?
The Murphy versus Corhertz case goes way back to 1928, talks only about there being some benefit by the employer, some benefit. And that benefit arose from the fact he could have left his phone at home, his company phone at home. The benefit was that it was available and it was part of his unique responsibilities. I'm not suggesting that everybody who gets a company phone and uses it for whatever comes up has those types of responsibilities. It was something that was unique to him. The reality is, and I'm reminded during the break, the Corps officer requested that nobody look at their phones, put them on silent and not ring and not look at them while we're sitting here waiting for oral argument out of respect or otherwise. But it reflects reality. Things change. The Daniels versus Prowski Clark case that we cited too. The Court of Appeals in that case indicated that was a situation where somebody had a briefcase with company materials and they were traveling to work, but they were, and the Court of Appeals panel in that case found that they in fact were working. They had the materials with them. They were they were a salaried employee. And in that circumstance, they acknowledged that there was responsibility, at least for purposes of having a jury determine. I believe that once the threshold is shown in terms of defining what his responsibilities were, acknowledging that that was his job. They cite to the Wu versus Johnson case. In that case, it involved a lawyer that was traveling for argument before the court that was scheduled at 11 o'clock, and he got into an accident on the way. And they said, well, his regular job starts at 8 o'clock or 9 o'clock. And this was at 10 o'clock because his argument was later. He had not yet arrived or clocked in. And this is different. He acknowledged, based on the testimony, his employer acknowledged that he was working. Mr. Wright acknowledged that he never abandoned responsibility to his employer during this drive. So the question isn't whether, as Judge Rowe framed it and didn't look or discuss any of these other issues, the reality of the facts in this case was, what was the purpose of the drive? And he indicated, well, the purpose was to go to the dry cleaners. And the real issue, and I said that and I'm repeating myself at the start because I think it's a reality, is whether he was working while driving. All right, not what was the purpose. And if you
And
look
whatever,
at,
okay, let me stop you there then. If your argument is that he was working while he was driving, either he looked down to read an email or he was pulling out the phone to make a call on his work phone, whatever that is, they present, K-Max and defendant produced testimony that I didn't check the phone and there's a timeline for that. What do you have to rebut that?
the timeline
Production.
the timeline doesn't make sense. Mr. Wright testified. When he hit Mrs. Henderson as a pedestrian, he dragged her for almost 100 feet. He didn't see her. I don't know what he was looking at or thinking, and did not stop until she had banged up. That's why she was injured so badly, until he heard her screaming under the vehicle. Never hit the brakes, never saw her. In terms of what he was doing, what he was thinking, certainly there's an inconsistency. When he says he was going to the dry cleaners, he suggests it was after the emails came in on his phone. After he left, he responded to those emails at the scene. He's looking at Mrs. Henderson under his truck, right? She is unconscious. He called the police the next day to find out if she was alive. And he suggests that his instinct, when he got picked up because his car was impounded, his truck was impounded, that his instinct was to answer this his biggest customer answered that email, right? Because they were about to lose millions of dollars and perhaps a large Ford account. And when his wife came to pick him up, he decided he was going to go to the dry cleaners. And it took 24 minutes in the timeline. They didn't produce it. We were able to get the dry cleaning, the dry cleaner, Sullivan Dry Cleaners, that is 1.5 miles away from where the scene is. And it took 24 minutes because we saw when his debit card was run, 24 minutes later to drive 1.5 miles. And the instinct, the credibility that it took 24 minutes to get there, that here he struck somebody and almost killed her. He didn't see her. And his instinct was to go get dry cleaning. That was for work. And his wife testified there was no personal, there was no wedding, there was nothing they needed on an immediate basis.
Right. Counsel, I think we understand your point on that. Is there anything else
I would,
on your primary argument that you wish before we hear from Appley?
I think that the Murphy versus Kahertsky case, even though it's an older case, is on point. It suggests, and that's a Supreme Court case, suggests that the purpose, when something occurs for purposes of vicarious liability, doesn't have to be entirely for the employer. You don't have to be driving a truck in the course of delivery or something. All it requires is some responsibility, some duty. It doesn't have to be everything. And in this case,
In that case, the defendant was driving the company truck and was required to return it back to the employer that night. He wasn't allowed to keep it overnight. So he was taking the company truck back to work.
but
Isn't that quite a bit different than this situation where the plaintiff is in his own car and is going to get his own dry cleaning?
Yeah, the purpose of that in the purpose in that case, it was to benefit, again, going back to that standard of who did that, what was the benefit of that?
And I'm going to distinguish the case I cited myself. But in that case, it was in 1928, right? They had no cell phones. They had no company phones. And the way people did business wasn't post-COVID. There wasn't a job created for account executive, remote account executive, sales engineer to carry a company phone, to do so at all times during work, not when he was off. Not during lunch, all right, but he was working. It is no different and reflects a reality that I think that isn't necessarily applicable in every case, but certainly something worthy of a jury to review, was the extent that he was working during that time. And we know he didn't leave his phone at home. We know he generally did that when he was not at work. He was monitoring in this particular situation a very, very volatile, something that could cost him his job or a multi-million-dollar customer for K-Max. There was a defective part in a plant was shutting down for Ford Mexico. The number of emails, and we didn't get to see the content because they were redacted. And when we deposed half dozen employees who were identified in the emails, they all lost their memory and didn't have any recollection of what was actually going on. But they did acknowledge the people that were being called, that the emails were marked, high importance. And there was an extraordinary amount of activity. He was working. The company received some benefit from the time period he was in his car because he was monitoring his phone. And in fact, we know that because he actually answered these emails while at the accident scene, which is remarkable by itself. And the emails came in after he left from the house.
Didn't he testify that he answered the email while he was in the car while his wife was driving him to the dry cleaners?
No, he did it on the scene because we know that he was still there when before the vehicle got impounded. And the email is before his vehicle's impounded and before he left. So the time frame puts it him standing around while the EMS within the same time frame that the EMS is tending to and loading Mrs. Henderson into the back of the vehicle. Right at that time frame, he's responding to these emails of this plant shutting down in Mexico. It is a factual scenario that we believe that a jury should have decided. Was he doing enough?
So your position is that it's a question of fact for the jury to determine whether or not he was acting in furtherance of his duties, or is that a question for the judge as a matter of law?
Yeah, the judge in this circumstance only looked at the purpose. He declared that the purpose was personal. He looked at and provided no analysis.
Are you saying that was you're just saying that that's the wrong conclusion, or is that not his purview?
Well, I think it's both. I think that we satisfied the threshold in terms of there being some duty he undertook, and it was admitted by Mr. Wright. He admitted that he never abandoned his responsibilities. It was admitted by his employer. It was admitted by Mr. Wright by saying he kept working. He never stopped working. And
Counsel, if you want to save time for rebuttal, you might want to wrap it up and address any other points that you want us to be aware of.
At this point, I would like to save time for rebuttal. I don't know if the panel has any questions.
Any further questions?
No.
No
Thank
further
you.
questions. You have time for rebuttal. Counsel?
Good morning, Your Honors. Well, I respectfully disagree with the characterization of facts in this case and the application of law. I think the trial court got it right. Appellant would like to reshape Michigan law to mean course and scope to be available for work, working while driving, however you want to say it. I think Michigan law has been clear since 1928, 1930, that course and scope basically means, were you engaged in the service of your employer, or were you about your employer's business while the negligent act happened? Here, he was driving to the dry cleaners. He admitted at his deposition he was going during his lunch break. He ate lunch with his wife, and he had time before he went back to work to go pick up his dry cleaning. That's what he was doing. Unfortunately, was looking at oncoming traffic, and Mrs. Henderson came, from the opposite side, and he had a truck and he didn't see her. And that's very sad. Nobody wants that to happen. But that doesn't mean that my client's vicariously liable for Mr. Wright's negligent act. I think the Supreme Court, Court of Appeals, trial courts have clearly stated throughout the years that course and scope is not synonymous with the time period of employment. You have to look at what was going on and whether it benefited the employer or was it about the employer's business. And I just don't think the evidence here supports that. In addition to the testimony, KMAX not requiring him to drive that day, I do think the email timelines show he sent his last email at 11:24 a.m. The accident happened at 11:44. So he didn't email for the 20 minutes before. The EMS records show they were called at 11:46. They got there by 12:01. They got her out of there by 12:04. Good for them. And they got her to the hospital by 12:11. He sends his next work email a good, 15 minutes or so after that at 12:24 when, as you stated, Judge, he said he was in the car. His wife had picked him up. So he's not at the accident scene. I respectfully disagree with the characterization of the record on that point. The suggestion that the dual purpose rule applies, I disagree with that point. Under Michigan law, the dual purpose law imposes vicarious liability if an employee is driving to or from work and there's also some sort of service or benefit to the employer, which I don't think this like tangential being on call, having your phone qualifies. I think Michigan law is clear. It has to be sort of a specific benefit, if you'll call it that.
If there was
Such as like
evidence,
a business trip, a meeting, driving, something connected to the job besides you want your clothes to look nice for work.
is there evidence, if there was evidence, and we're a little bit handcuffed by that because the motion to compel wasn't granted, but if there was evidence that the email had been read while he was in the car, would that be a sufficient tie-in to state that at that point it became a dual purpose?
I don't think so, because I think Michigan law, as Judge Rose said, is the purpose of the trip needs to be looked at as a whole. And the purpose of this trip was not to serve his employer. It was to pick up his dry cleaning. For those reasons, I believe you should affirm the trial court on the vicarious liability, granting a summary disposition under C10. Do you have any questions on the discovery issue?
I guess the question I have is, what was the basis for only providing, my understanding is that there was a timeline provided or a record that provided the time that phone calls or text messages were being sent,
Correct.
but
You're
none of the
correct.
content.
Yeah, the purpose of that, there's nothing to hide. It's business proprietary. KMAX didn't want the names of its various companies out there unnecessarily.
Wouldn't that be an easy redaction? I mean, when I did discovery like that on behalf of employers, we may redact which company it was or the value of the contract or the name of the part or those types of things, but the rest of the emails.
My understanding is they went back and forth on that, but they really felt that he got the information he needed from the timelines and seeing the dates and the names of the parties who were involved in the emails. And this, at least with the September 17th order, it was denied without prejudice. The judge said, you just didn't give me enough information. You're welcome to come back, which he did not do.
Fair. Any further questions?
Thank you.
Counsel? And why don't you start where Sister Counsel ended? Why not renew your motion before the trial court to compel and provide more information, more argument on why you needed the content of the texts and emails?
Because the response was that they don't exist. And when we requested that.
But wasn't that was the answer to the personal cell phone and emails, not to the KMAX one?
KMAX
It's two different phones, right?
Yes. And KMAX said that the text messages don't exist. He called somebody from the accident scene. He called his wife. What else did he say? What else did he have? A forensic examination of the phones would have revealed that activity, would have shown the number that was called, and we could identify who it was, when it was.
Discovery rules impose a burden on the requester to show that it's proportionate and necessary to the needs of the case.
They do.
And what
in this
then
case,
did you argue to the court that provided that argument?
the fact that they said they weren't available. So it was proportional to the needs of the case. It goes to what was he doing during that time frame, during this drive? Was he working? And did the employer have a benefit from him having this phone with him, being able to receive, respond? Somehow the emails that are at issue during the drive came in after he left. He read them. He had to have read them, thought about them in order to respond.
Was there any inspection of the Dodge truck to determine whether it was paired with the work phone?
There was not. That truck was, I understand from the model, the make and model, it was capable in terms of pairing, in meaning that they would show up. Again, a reality that didn't exist when the Rogers case or the Murphy case.
Was there anything in the record indicating whether or not that specific 2019 Dodge Ram truck was capable of exhibiting the text messages and on a dashboard or something similar?
Or read them?
Yeah, I believe I asked that question. I looked up, I Googled the car and vehicle and the model, and it was relatively new. And it showed that it was in fact capable. I asked Mr. Wright, if I recall properly, and he said he didn't know. Again, there was a lot he said he didn't know or didn't have memory of.
Were subpoenas ever sent to the service providers?
They were. And the service providers responded that they didn't have anything, that it had been, that it hadn't been retained, the information wasn't available. I'd indicate that with respect to the company phone, that information was available. We had offered to enter into a protective order. If there was any proprietary information, this wasn't a trade secrets case between competitors. We weren't interested and weren't going to divulge the individual information. We don't know what was redacted, but I know because of the redactions, when we took the depositions of the individual employees, and we took half dozen of them, that were part of the emails, nobody had any recollection from looking at the email what was going on. They acknowledged in part that there was this issue with Ford Motor Mexico, and they acknowledged that at that time there was this defective part that was shutting a factory down.
Yeah, we understand those, and you've got about a minute or two left. So if there's other points you wanted to rebut, I'd encourage you to move to those.
I'm sorry?
I just encourage you to hit those points, because the facts we know, and you've hit those, you've hammered those points home. We're very well aware of those.
Thank you. The dual purpose rule. Again, you're looking for some benefit, not just a service, but some benefit for the employer, to the employer. Clearly, during this trip, he would have left his phone at home. What's the purpose of having a company phone? If not to use it outside of work, outside your home where there's a landline. It's because it's connected anywhere. There's a benefit. And again, I'm not suggesting everybody was a company phone, but here clearly there was a dual purpose during this trip, and things were going on, and he responded, he used it during this trip. And those facts support that. In fact, there's a dual purpose. And again, going back to Murphy, the purpose in what Judge Rowe looked at was only what was the stated purpose of the trip. And you don't have to have that. You can, and Murphy says there's just some benefit to the employer. What was the benefit? And again, the issue is not, and I'll conclude.
So let's say I guess, I don't know, maybe that's not the correct analogy, but he has the phone and he leaves and drives up north, right? Like and accident happens at 7 o'clock at night.
Right,
There's a benefit for his employer to have that phone with him because he's going to be up north for the weekend, but the purpose of the trip was to go up north.
No, I agree. And we all know that while you're driving,
So
And
why
it's
is the
during the
purpose?
week that you look at your phone and you respond to, you know, clients that have emergency, respond to things that are happening, emails you get from the court or otherwise. In this particular case, right, we know that he was working. Mr. Wright's
Well,
own
what's the difference
testimony
between
says.
going back to the purpose of the trip and looking at that as a key factor? If the stated purpose that appears to be unrebutted, or if it is determined to be unrebutted, that he went to the dry cleaners. I mean, he testified that, his wife backed that up. He indeed went to the dry cleaners. Why is that not conclusive of what the purpose of the trip was?
Because it's not just in this reality, post-COVID, remote work. In this particular unique job that wasn't available pre-COVID, the responsibilities he received as an account manager, as a sales engineer, to be, you know, during the course of the day, to be married to that phone, to bring it with him. He didn't leave it at home. He wasn't checked out. And that was a benefit to the employer.
Okay, I think we understand that piece of the argument.
And I'll finish with, you know, just the, because I think it reflects the sentiment. I recognize there's case law out there that talks about the purpose of the trip. I think that's a lot of that is outdated. Even the Daniels case that's closest is a 2009 case that, you know, is a dozen years before COVID. And COVID changed things. People work, you know, while they're driving. You know, and if your purpose is to drive to the dry cleaners, were you working while you made the drive? Are you working during the course of the day? If you aren't working, why bring the phone with you? What would be possible purpose if that's all he said he was doing was going there and back? Why? Why leave? Why not leave it at home? You know, he had the ability outside of that phone. He had a company issued laptop at home. He could have worked from there. He had a landline. He could have done things from there. He didn't. He chose to bring it with him. That's what's different in this case. And I'm not suggesting a broad rule. I'm suggesting that in this particular circumstance, KMEX created a position that's particular to this employee, that he has to act as a coordinator liaison. That's all he did. All right.
Okay, counsel, I think we understand all those points and those facts. Any other questions from the panel? No further questions.
Thank you very much.
Thank you, Judge, or thank you. Jeez, I'm used to being on the other side. Case number 9 is submitted. Calling item 10 from the docket, case number 369112, ACV State of Michigan.
Good afternoon. May it please the court. Assistant Attorney General Mary Waddell appearing on behalf of the defendant appellant, the Michigan State Police in this matter. Your Honors, the court can quickly dispense with this appeal and reverse the trial court for 2 reasons. First, in Christie versus Wayne State University, the Supreme Court has made clear that all claimants must strictly comply with the notice requirements of the Court of Claims Act in order to overcome the state's sovereign immunity from suit. Second, this court's recent decision in Hudson 2 has made clear that the Christie decision is fully retroactive. In this case, there is no dispute that the plaintiffs failed to comply with the notice requirements of the Court of Claims Act, Section 6431. Therefore, dismissal is required as they have failed to overcome the state's sovereign immunity.
I mean, at this point, it's really just an issue of arguing to the Supreme Court that they should overturn Hudson 2, right?
Exactly,
Which
Your Honor.
this panel cannot do.
Correct. So based on that, the trial court erred in holding otherwise. Therefore, the trial court decision should be reversed. And unless there's questions, I'd reserve the remainder of my time for rebuttal.
So reserved.
Thank you.
Good afternoon, judges. Julie Hurwitz on behalf of the plaintiff appellee with my co-counsel Teresa Bingman.
I fully understand the procedural status of our case right now. So at this point, Your Honors, what I hope to be able to present to you this afternoon is a opportunity to send a strong message to the Supreme Court. I would like to address a few of the factors that I think are pertinent to the issues that pertain to this particular case, and how it would be very important to recognize the problems, the significant problems with the analysis that the court used in Hudson 2, which I think are fully addressed by both the dissenting opinion of Judge Feeney and also the concurring opinion of Judge Young, who recognized that Flamont and Flamont and Landon, the two cases that were being analyzed by the Hudson panel, were not properly analyzed. And even Judge Young, in her concurring opinion, recognized that the finding in Flamont resulted in an injustice and was wrongly decided, particularly as it pertains to the specific situations of our case and many other cases that are currently pending, either in this court or on application for leave to the Supreme Court as we speak. The Hudson 2 opinion, none of the cases, by the way, and I want to raise this as an issue to grapple with, none of the cases that have been addressed by the courts, either this court or the Supreme Court in Christie, looked at a very specific provision of the Revised Judicature Act that governs litigation of cases before the Court of Claims, and that is MCLA 600.6422. And that's the case that specifically defines the scope of the Court of Claims jurisdiction over cases that are brought against the state. And in 6422, the rule or the statutory provision specifically provides that these rules that are in this provision of the Revised Judicature Act apply to cases that are litigated in the Court of Claims. And 6431 follows from 6422, and there's nothing in 6431 that addresses any types of claims against the state that are not filed in the Court of Claims. And so I would suggest to this court that it is imperative to incorporate the understanding of 600.6422 into its analysis of whether or not, in this case, there should have been a notice of intent filed when the Elliott Larson Civil Rights Act was being enforced as it statutorily was entitled to be enforced with a jury trial in the circuit court and not the Court of Claims. I would address the Pohusky factors, but I won't, because I think this court is fully familiar with the questions once a determination is made of whether there was a new rule of law. And it's the new rule of law prong of the analysis that we strongly urge this court to take on and to address the just glaringly incorrect conclusion that any case that was relying on a published Court of Appeals opinion, which is the the Terrell case, just so you get a sense of the chronology of what happened in our case, the Terrell case was decided in 2020 as a published opinion. Our cause of action didn't even arise until 2021. And was filed the following year in 2022, immediately before, I believe I've got the chronology correct, but let me make sure I do. Yes, in June of 2021, excuse me, almost a year before we filed our case. Well, Terrell was first decided by this court sometime in 2020. In June of 2021, the Michigan Supreme Court denied leave in Terrell. And this was
Council, we're very familiar with the cases cited and the progeny that led up to the Supreme Court's decision. So if you could focus in on any points you want us to perhaps consider it and state, even though we're bound by our Supreme Court precedent, I'd focus in on those.
Well, I would simply urge this court, while I understand the writing is on the wall in light of Hudson 2, I would like you to take the opportunity to send this message to the Supreme Court that they should and must grant leave when this case comes before it. They must revisit the parameters of how the Christie case should be applied for all pre-Christie filed cases that have been pending prior to the issuance of the Christie opinion. And further, take a look at MCLA 600.6422.
Looked at it, and I think Judge Feeney's argument is a lot more persuasive than that statute.
Absolutely. Well, Judge Feeney's argument is very convincing, and we agree with it wholeheartedly. And that's one of the things I want to address that Judge Feeney took on, which is the manifest injustice that will result, not just for our clients, but for every litigant who is attempting to exercise their right to have access to the courts and who are left with no remedy, no relief, and no right to litigate their claims. Our clients, were left completely without any remedy. At the time that they filed this case, they were abiding by the published opinion of Terrell. And I will point out, there was another published opinion in 2018 that seems to have gone by the wayside, Doe versus Department of Transportation. In that case, again, the Michigan Court of Appeals, in a published opinion, specifically acknowledged the applicability of, not so much the applicability, but the fact that there is no requirement to file a notice of intent when a case is pending in the circuit court. What happened in that case was that the plaintiff filed the case in circuit court, the defendant transferred it to the Court of Claims, and while it was pending in the Court of Claims, the defendant filed a motion for summary disposition on the basis that the plaintiff failed to satisfy the pre-filing requirements of 6431. The Court of Claims properly saw that this was inappropriate and acknowledged and recognized that the case was properly filed in the circuit court, transferred it back to the circuit court, and dismissed the motion as moot because there was no issue before on that. There was no
Ms. Hurwitz, I was on the Landon panel, so I certainly understand your arguments, but I also know that we are bound by Hudson 2 as a conflict decision that came out of our court. But hopefully our Supreme Court will take a look at this, and these are great arguments that you can make in front of them.
Yeah.
Thank you, Judge. I would like to just leave the court with a quote from former Justice Ryan in the case of Tebow versus Havlick. And that is, which I believe is absolutely pertinent to what is happening here. And I quote, "It is enough that lawyers and their clients must run the risk and pay the price of erroneously anticipating judicial decisions interpreting the meaning of statutory language. They should not, at least in these cases, be penalized for following such decisions." And I look forward to a powerful argument that will convince the Supreme Court that this is an issue that must be revisited and fixed.
Well, for what it's worth, I was on the Walton panel with Judge Feeney. Thank you.
Thank you. Judge.
Thank you. Any rebuttal?
No rebuttal unless the board has questions.
No questions.
Thank you, Your Honors.
Thank you. The case will be submitted. And with that, we're going to take a very short recess and come back and try to wrap up today's case call.
All right.
Thank you for your patience. Calling item number 11, Case number 372414, In re Douglas Ladney, 1992 trust. Counsel, you may approach and state your appearances for the record.
Good afternoon, Your Honors. Brian Sonislow appearing on behalf of the appellant and respondent Shelley M. Lawson, who is the personal representative for the estate of Douglas Ladney.
You may proceed.
It is our position that Judge Shemke was clearly erroneous in granting the appellee's petition for declaratory relief. And the reason that I'm taking the position that she was clearly erroneous is because she concentrated on one issue and one issue only, and that was 3.2 of the trust agreement that was prepared by Mrs. Ladney back in 1992. As you may recall, the trust had two provisions in it that I addressed in the course of my brief, and that is 3.2 and 3.3. In 3.2, the trust made reference to having a notarized document, albeit the will, whereas in 3.3, it makes reference to the power of appointment, a power of appointment. There is a definite conflict between 3.2 and 3.3, and therefore, based on the fact that there's a conflict, she was clearly erroneous in her decision to grant the petition for declaratory relief. But that was not the only reason that she was wrong. And if I may just take a few minutes to go through some of the key factors that I referenced in my brief, I think it would be significant. First of all, there was a lot of innuendo about the relationship about Douglas Ladney and his family and whether Douglas had problems and so forth. Douglas Ladney was the beneficiary to the trust. There's no question about it. But the affidavit that appellee makes reference to, which was prepared by his brother, that talks about his mental condition when he was 17 years of age, clearly has no reference or no relevance. Doug Ladney was clearly estranged from his family. He didn't want to have anything to do with them. And in fact, he didn't even want them to know that he was dead. There's no evidence in the record to suggest that Douglas's signature was not authentic, or that when Douglas Ladney prepared the will on 11/11/2023, that he was under duress. And accordingly, the power of appointment in 3.3 doesn't place any restrictions on the type of will or document that he could have prepared. It just makes reference to a power of appointment. And under the statute, a power of appointment can be accomplished by virtue of a will. And there's no question in this case that the will was in fact admitted to probate and was a valid will. So moving on.
Well, how did it have all the formalities of a deed?
It didn't have all the formalities of a deed. But as I indicated in my brief, those are technical deficiencies that under the law could be looked at in a manner that it would not make a difference.
But doesn't it suggest though the intent of the drafter here was go ahead and make a will, but I want to make sure that will is notarized or it's authorized by a clerk or by a judge.
You know, I'm taking the position that Judge Shemke and the appellee are viewing this case based on the requirement for a notarized will, which is one not required under the law. But more importantly, I'm asking this panel to take into account the real intent of Margaret Ladney, his mother, when she drafted the trust in 1992, because that is truly what this case is about. The intent of Mrs. Ladney to provide a means for her son to distribute up to 1/2 of the trust upon his death. It's clear and unambiguous that this was her intent. If it wasn't her intent, she could have clearly cut ties with Douglas to leave anything upon his death at age 69.
What do you base the argument that the deed doesn't have to be notarized on? And the reason why I ask is because I'm looking at the statute, which is 565.8, which says deeds shall be acknowledged before any judge, clerk of a court of record or notary within the state. So 565.8 suggests to me that it has to either be notarized by a notary or acknowledged by a judge or a clerk of the court of record. So how can you really argue that a deed doesn't have to be notarized?
I'm not arguing that a deed does not have to be notarized. I'm sorry if I misunderstood or if
I probably misunderstood.
Yeah, I am not arguing that. What I'm saying is there's been a change in the law. In 1992, a deed had to also be witnessed by 2 individuals. No longer is that the case. There's been a change. So a deed still has to be notarized, but a deed is not the only, a power of appointment doesn't make reference to requiring a notarized document. And that's what I'm saying about the distinction or the conflict between 3.2 and 3.3 of the trust.
Well, is it possible to read those two in harmony? Can I look at 3.2 and 3.3 and say, okay, essentially what it says is that you can have a will, but it's going to have to be notarized. And then if it doesn't turn out that under section 3, if it turns out that you didn't leave issue, in other words, you didn't have any children, and you didn't exercise the power of appointment, which was the will that would have to be notarized, then here's how we're going to distribute the trust assets when you die. Can't we just read the two in harmony in that manner? What's the problem with that?
I see your position. However, I'm saying that the doctrine of severability would apply, and we should remove the requirement for notarization if the will is otherwise valid as a power of or under the law that deals with power of appointment. I think that's the reason that I take issue with Judge Schemke's decision, because that's exactly what I'm proposing is exactly what should have occurred. Furthermore, there's an issue of public policy here. She makes reference to obvious public policy reasons such as marriage, discrimination, whatever terms that are clearly against public policy. But the common law also says that if a provision is frivolous, and again, referring to the common definition, meaning not having any purpose or value, and I argue that that is the case we have here. There is no purpose or value to having it notarized. He was 69 years of age. Yes, he was close to death at the time that he prepared the will, but the will is very, very, very specific in terms of distributing what he believed to be his assets to friends and other individuals who helped him during this period of time. Furthermore, there's
an argument against like the public policy. Don't you want to have it notarized so that you're positive that it's actually him at his age and he's got a bunch of people around him, he's close to death, and it's actually him signing it? And isn't that the whole intent of the notary?
Well, that's
requirement.
Sure, that's one intent, but it was witnessed, and In fact, it was witnessed by two individuals. It was admitted to probate and nobody objected. The court admitted the will to probate. So therefore, where's the issue?
How about the intent of the drafter that wanted the will, if it was going to be executed, to be notarized?
What I'm saying, though, is the intent of the drafter was that he, being Douglas Ladney, should have the right to make a distribution through a power of appointment after his death. That's why I'm saying there's no rational basis for 3.22's requirement. It's just contrary to the interest of Mrs. Ladney or the intent of Mrs. Ladney. I mean, if she didn't want him to have that power, she should have simply indicated. So
But couldn't they have easily, I mean, they got two witnesses, couldn't they have gotten a notary?
they could have, yes, but at that time, for whatever reason, there was no notary. I can't give testimony because, as you know, I was involved in the drafting of the will. And I was also a witness, and the will was also done at the American House in Roseville, Michigan, and I was told that there would be a notary there. And quite frankly, there was no notary, but
Who was the other witness, Miss Mbusi, or?
oh, I'm sorry, I didn't mean to interrupt you. No, she's an assistant at my office.
Not a beneficiary under the.
Oh, no, she is not. And she is not. She had, quite frankly, only met, I believe, Mr. Ladney that day. But that's not uncommon. My assistant will usually witness wills. In fact, she's now a notary. So, but that doesn't, you can't go back and say, well, she's a notary today, but you know.
Save that $125 every 3 years or whatever it is.
Well, whatever, but my point is that you got to look at the intent of Marguerite Ladney as opposed to 3.2. And then I talked about in my brief technical deficiency under 700.2503 that this was a harmless error. Nobody is suggesting that this constituted the type of error, if you want to call it that, that would negate the intent of Mrs. Marguerite Ladney to allow her son, who was quite frankly estranged from his three siblings, to leave property as he so determined. So based on all these factors, the doctrine of severability, the public policy doctrine, the doctrine of technical deficiency, these are all factors in my favor that requires the court to set aside the decision made by Judge Shemke. I will reserve time for rebuttal.
You got
Thank
it.
you.
It's reserved. Any more questions before we?
Oh, I'm sorry. Any more questions? No.
I got you covered. Don't worry. It's my job.
Good afternoon, Your Honor. May it please the court, I'm George Constance. I am the successor trustee of the Douglas Ladney 1992 Trust and also appellee here. I executed my duties as successor trustee for approximately 5 years before Doug passed. And I know this trust, and I will say that the settler of the 1996 trust, of course, was Doug's mother. The trust was irrevocable in 1992 when executed, and Doug's mother is now deceased. In the trust, Doug's mother allowed for her son to create an estate plan later in life if he chose to. We'll see in this case, he apparently chose to. Doug's mother placed a lawful, plain English condition precedent and must be satisfied in order for an after-formed estate to access Doug's trust upon his death. And the only condition Mom put into this particular trust was that the will in this case should have the formalities of a deed. The observations made by Judges Wallace and Treblecock, I'm sorry, are accurate in that she requested that the deed be notarized, and there's a good reason for it, which I'll get into in a bit. The trust, if you read section 3.2, would allow for if the will were properly executed in 2023, it would have been notarized, in which case the estate would draw one half of the trust corpus for distribution. The other half would go to Doug's living brothers and sisters. Didn't happen here. We'll never know why the deed was not notarized. It was either missed in reading the trust or intentionally disregarded. And I will say here that the appellee considers section 3.2 where Doug can have a will that's notarized. And if he doesn't have anything like that, section 3.3 says the trust will go to his brothers and sisters. To me, it's a bright line distinction. It's a either or, and no legitimate basis, no lawful basis was presented to the court at the lower level as to why this was not notarized.
What about appellants? How do you respond to appellant's argument that is just a technical deficiency?
Absolutely not, Your Honor. I disregarded at the lower court level. I disagree at the lower court. And I disagree here. He'll argue that it's irrelevant. Appellant will argue it can be severed. Appellant gives in his appellant brief a hypothetical that Mom could have done it differently in 1992. Having a notary is against public policy. I discount all those. To me, it's a very simple, generic way for anybody, including the statute regarding deeds, to allow for that the signature be. Notarization is a three-part process. That the signature is authentic, that the document is genuine, and that there's no undue influence and it's of this person's own free will. A lot of people look at a notary and say, oh, okay, they've certified the signature. Well, there's more to it than that. And there's a reason Mom put this in to have this notarization, because I'm told, even though I was not aware of what was happening, Doug was removed from the American house where he was living.
This relevant to why is this relevant to looking at just the plain terms of the trust and what happened or did not happen?
Its only relevant, Judge, is to legitimize why Mom put it in, that it's lawful, and to show Mom may have been right in 1992 when she drafted the trust that it should have been notarized, because he was removed by the now personal representative of the estate from his American house room on November 10th of 2023, apparently signed a will November 11th. And I think the lower court record shows it wasn't at American house, it was at a law office. In any event, it was not notarized. And I say that because I, as trustee, had no idea where Doug's whereabouts were from November 10th of 2023. He signed apparently on November 11th. I had no idea where he was, even though we called looking for him, until December 5th. And then he passed away on Christmas Eve later because he had a pig tooth and tracheotomy. One of the reasons for his passing was malnutrition. And I don't know how somebody dies malnourished in the state of Michigan in 2023, but he did. So they got their signatures, and he died a couple of weeks later. The only relevance being, Judge, I think it's as important now as in 1992 when Mom put this in, that someone had to, in this case, an impartial observer, like a notary, had to look over Doug's estate plan if he decided to do it.
Your position is plain language, notary requirement, no notary, no valid point.
Yes, sir. The lower court held it's a valid will, go out and administer to your estate. The estate has asset. I gave the estate a Citizens Bank statement a Western Life Assurance bank statement, and I think Prudential. So there's assets there. And the court also held at the lower court, trust, you do your thing, Will, go do your thing. But Will, you're not going to, since you didn't satisfy the condition precedent, you're not taking one half this trust with you. So yes, Your Honor, your observations are correct.
Any other questions? Any other questions? You have a brief time for rebuttal.
Very briefly, a lot of the points that Mr. Constance made, as you indicated, are not relevant. Where he signed the will, what happened at the end of his life, why he died, those are not relevant aspects. The bottom line is that the lower court did validate the will, and whether or not there was $1 in assets in the probate estate, or whether or not he was entitled to half of the estate or half of the trust assets, is really not relevant. The question here is whether or not Judge Shemke was clearly erroneous in her short-sightedness in ruling that because it was not notarized, the intent of his mother should be totally ignored.
So is your position that a trial court that enforces the plain language of a trust agreement, that's reversible error, that's clear and obvious?
It is my position based on the fact that there's a statute that talks about deficiencies. And quite frankly, in that, I cited a case in my brief that talked about the fact that the attestation clause was not proper, yet
That didn't exist in 1992. That didn't come into effect until April 1st of 2000 when Epic went into effect, right?
absolutely, I'm not arguing when it came into effect, but the bottom line is that it would be applicable in this case to determine the validity of the will as it pertains to the trust.
Because it was drafted in 2023 as opposed to 1992.
Exactly. So from that standpoint, I'm taking the position that Mrs. Ladney's intent was not to deprive her son of the right to make a distribution, but simply if he did so by virtue of a power of appointment, i.e. a last will and testament.
Are you saying the attestation clause from Epic, which started in 2000, is the equivalent of what a notarization would have been back in 1992?
In 1992,
Under the revised code.
the law is still the law that a deed has to be notarized. It doesn't have to be witnessed today. I mean, the law has changed.
Right, but I think what Judge Wallace is saying is that the only way your argument survives or is valid is if what you're arguing is that when Epic came in, that meets the standards of what a notary did in 1992. I'm restating that.
I was just wondering if that's what you were arguing.
Yeah.
It sounded like that's where you were going, but I wasn't sure.
Well, I don't think that issue has ever been resolved, whether or not Epic would require notarization. I mean, it's clear that the law doesn't require notarization.
So you're saying the
It
best,
only requires an attestation.
so if I understand it, your best argument is that either public policy or technical deficiency, or you should be able to sever the notary requirement out for all the reasons you listed in your briefs. Those are the 3 points. Ignore the plain language for these 3 reasons.
What trust can be deemed to be invalid based on public policy. And as I indicated, the public policy in this case is such that this is a frivolous clause.
Isn't the public policy of the state that people who draft trust agreements expect them after they're dead. They're going to be enforced by trustees and upheld, and courts are going to uphold them. And that it's not going to change just on the will of the legislature or anybody else.
Unless it's determined that they should be severed and that it's against public policy. That's all I'm saying, is that in this case, there is no rational basis to deny the last will and testament as it pertains to half of the assets of the trust.
Okay. Any questions? We understand your position.
Thank you.
Yeah. Thank you both for the argument. It helped clear it up in my mind. I know. All right. Docket number 11 is submitted. Calling item number 12, case number 373804, Varchetti v. Varchetti. Counsel for the appellant.
Kate Klaus on behalf of Paul Varchetti. We have an embarrassingly straightforward issue for the panel on appeal, given some of the more complex issues that we heard this morning and into this afternoon. The first issue is, did the trial court err when it held that Michigan law and policy bars the parties' agreement to arbitrate their post-judgment disputes? The second issue is, did the trial court abuse its discretion in awarding Mrs. Wade her fees when it denied her motion and found that Mr. Varchetti was not in contempt? And the answer to both questions is yes. The dispute in this case concerned the scope of Mr. Varchetti's obligations in the marital settlement agreement to pay his ex-wife's fees for experts and attorneys. The marital settlement agreement that was incorporated into the judgment contained an arbitration provision that provided language disputes in the settlement and judgment would be subject to arbitration. This is a perfectly valid provision of an arbitration agreement under Michigan law. The Domestic Relations Arbitration Act expressly allows arbitration in contested domestic relations matters. Post-judgment disputes, like the one at issue here, are routinely arbitrated, and this court has repeatedly upheld the validity of those proceedings. But the court in this case determined that this provision was contrary to the law and public policy of the state of Michigan, and that she was not able to send the parties' post-judgment dispute to arbitration. The court said the parties could come to her and ask her to send the matter to arbitration, but that they needed her permission to do so, and that the provision in the judgment wasn't valid.
Counsel, what I understand exactly your point is on that, and that you can send post arbitration. What I struggle with in reading and trying to reconcile is you've got a settlement agreement that says, hey, here's some stuff that goes to arbitration. And then you've got the judgment of divorce, which has Article 20 that also retains jurisdiction and says the court may interpret and enforce.
Right.
So how do we reconcile those two provisions?
The judgment also incorporated the settlement agreement. So the ability to interpret and enforce coexists with the obligation to arbitrate. So we read that as the court obviously retains jurisdiction to enforce the judgment, and it has the right to interpret the agreement. Sounds like our clients, maybe a little bit, but
right,
a little bit. But it retained the jurisdiction to determine whether something was subject to the arbitration provision, right? I mean, the parties could agree in their agreement to say arbitrability could be decided by the arbitrator. They would have that right. But the judgment of divorce makes it clear that the court determines arbitrability. It reserved that right to the court. And that's how we reconcile Article 20 with the arbitration provision in the settlement agreement. And the arbitration agreement is also narrow in that it applies to language disputes. It doesn't cover every element of the judgment of divorce, but language disputes.
Help me understand. So give me an example of a dispute that the court will interpret and enforce versus a language dispute. Like for example, I guess to me, it seems there are a lot of disputes that would require a judge to interpret the language of a provision in the settlement agreement and then enforce it. Why is this dispute over whether it's supposed to, I get the credit 160 or whether you're supposed to pay the full 160. I get all that. The real issue that I struggle with is this for the court to decide? Or is this to go back to the arbitrator?
Okay. An example would be, is it arbitrable? That's a question that the court would need to interpret the agreement.
Okay.
So the arbitrator doesn't
So
decide.
should your client have, instead of making a demand for arbitration, should he have gone to the court for the court to decide whether this is an issue and send it to arbitration, since the court retained jurisdiction over the?
He did do that. We did ask the court to send it to arbitration once we understood how Mrs. Wade was interpreting the dispute. This arose as a contempt because we didn't sign a quadro. That was clearly something the court had the ability to interpret the judgment of divorce and say, yes, you have to sign the quadro and enforce it. There was some confusion about whether we had notice of the show cause in that instance.
So under that, so the divorce settlement says you have to sign a quadro and you didn't do it.
Right.
Why is this different? Why couldn't the court look at the provision that says the 160 and then he can negotiate debt, et cetera? Like, why can't the court look at that and say, this is what I understand that to be. I don't think it's ambiguous. This is what plain language is. I'm enforcing it, and this is how I'm interpreting and enforcing, just as Article 20 provides.
Because the arbitration provision that was incorporated into the judgment of divorce says drafting and disputes will be subject to arbitration. And this is on page 5 of our appendix, section 5, and then A says specifically, the arbitrator will arbitrate any language disputes regarding the relevant documents.
Isn't it? But it says subsequent settlement documents. So language disputes, is that in the question is that an ongoing obligation for disputes for eternity as long as that arbitrator's alive? Or is it any agreements where the parties can't agree to get the settlement or to get the divorce finalized before the court? And then once it's finalized by the court, then Article 20 kicks in.
No, we don't read it that way because it specifically says drafting and disputes. It doesn't say drafting disputes. It says drafting and disputes, implying that it covers two things: drafting subsequent agreements and disputes over the language in those subsequent agreements. And it also expressly references the judgment of divorce. So the way we read it, and the parties demonstrated that they agreed that this was the way they read it because they did arbitrate a post-judgment dispute over whether or who had to pay the taxes on property that was assigned to Mrs. Wade. So that's how they interpreted it. They went to arbitration for that. And they should have arbitrated once we realized how Ms. Wade was interpreting my client's payment obligations. We asked the court to send it to arbitration because that's what the document provides. That's what the parties agreed.
One additional question I had was in Section 5 of the settlement agreement, it references including the final confidential settlement agreement.
Right.
Is that in the record somewhere?
No, there was no document other than the marital settlement agreement and the judgment of divorce.
Okay,
There might
so-
have been quadros and things like that, but no, this was the party settlement agreement.
Okay, so there was no other final settlement agreement,
Correct.
the marital settlement. Okay,
Correct.
thank you for clarifying that.
Sure.
Is this the final settlement agreement?
This is it.
This is it. Okay.
There, confusingly, there was also a proceeding in Florida that governed parenting time and custody, which is why the judge in this case crossed out some of the.
And isn't
proposed
that, I mean,
judgments.
isn't that sort of the heart of the dispute too? Because there's a lot of almost all the attorney fees from what I saw rose down in Florida
They did.
out of that dispute. And then husband, who's a collections attorney, negotiated deals down in Florida.
Did a very good job.
Yeah. I was like, geez, I need that on
He
everything.
did. And our position is he's entitled to the benefit of that. That's how we read the payment allocation part. But the judge in this case didn't even get to interpreting the arbitration provision because she held outright that it was invalid, which is clearly a mistake of law. And there was no discussion, no briefing below like there was here on appeal as to what the arbitration provision means. So we do believe she erred in that regard. And then when it comes to the attorney's fees, there was no basis for awarding the attorney's fees in this case. She found my client was not in contempt. So why does he have to pay the fees? You can't just say, you know, I don't like the nature of your arguments. I mean, there has to be a basis in the rule. There was no finding that Mrs. Wade was unable to pay the fees.
In the settlement agreement, though, there was a provision that allowed if you had to go to court to enforce and the court determined that there was a breach of a duty, then you'd be entitled to settlement fees.
Yes, that was in the
right?
judgment of divorce.
Attorney fees, right?
But there was no finding of that in this case. In fact, she found the opposite, that my client wasn't in contempt, didn't violate the order.
What do you make of in Article 20? You know, I've read this a bunch of times, and the court will retain jurisdiction to interpret and enforce any and all provisions of this judgment of divorce, including those found in the settlement agreement merged in between. So your reading of that would be that incorporates in the arbitrations provision, and I interpret the arbitrations provision to say language dispute, and language dispute includes a later dispute, not the drafting of the language, but the dispute about what the language means in the settlement agreement.
Correct.
Couldn't the court, I guess, is not an equally plausible reading of this, that the court could, instead of going to the arbitration provision, or look at arbitration and say, yes, some things go, but interpret the arbitration provision to say, no, this isn't a language dispute. This is an enforcement dispute on this section, which is clearly written, or that I interpret it that way.
She could find that it wasn't
Not that she
arbitrable.
did, but she could have.
Correct. She could,
Right.
I mean, because she determines arbitrability.
Right.
So she could define that this was not an arbitrable dispute. We would be here again because I think it is an arbitrable dispute, but she never got that far. Just
She just said it
for
was
some
contrary to
reason,
law.
she decided she wasn't, that the arbitration provision couldn't be enforced as a matter of law, not as a matter of the facts presented to her. And that's where she erred. And we also believe for the same reason she just blew it on the fees. You can't just say you have to pay $2,000 in fees because your opponent had to show up twice in court. You need some other basis. MCR 3.206D doesn't require necessarily a finding of contempt, but it does show that, or it does require that the other party refused to comply with the previous court order, and there was no finding of that in this case. There was a legitimate dispute over what my client's obligations were.
And you take the position that the $2,000 award had nothing to do with the quadro, right?
Correct, because that was, they said they served it with us. We showed that they didn't. Once we got it, we signed it, and that was moot by the time these proceedings came up. So,
And
thank
any
you.
other questions?
Thank you.
Thank you, counsel.
Good afternoon. Trish Haas appearing on behalf of the appellee, Julie Varchetti, now known as Wade. Judge Trebilcock, I think you hit the nail on the head here. What the reality of the situation is, and I've been a family law practitioner for 21 years, we routinely send matters to mediation, which is what happened here. We had a mediated agreement. But sometimes, even after the mediations, parties have disputes about what language should be included in the judgment of divorce, or what language should be in any ancillary documents, collateral agreements for security, et cetera. So this is a typical provision in all family law mediations that in the event the parties after mediation are unable to agree on the language that will go into the judgment of divorce or any ancillary settlement documents, that those matters shall then go back to the mediator, who will then arbitrate those disputes. But the difference is that once the judgment of divorce is entered, the arbitrator loses his authority in that regard, and it is left up to the trial court to enforce. And as you said, Section 20 of the judgment of divorce is absolutely clear that once the judgment enters, it is now the circuit court who has the authority to enforce the judgment of divorce. This was clearly an enforcement proceeding. Mr. Varchetti was ordered to pay up to $160,000 in fees. Well, what happened is he didn't do that. He didn't uphold his agreement. And instead, my client was sued in Florida for the non-payment of fees, and a judgment entered against her. This, not only did she incur attorney fees in Florida due to his failure to uphold his obligations under the judgment of divorce, but she also had to incur attorney fees to bring an enforcement proceeding here in Michigan. There's no way that the section 20 of the judgment of divorce can be interpreted in any other way than which I have provided in my brief. Again, pre-judgment, yes, the arbitrator retains authority, but once the judgment enters, it is solely the authority of the trial court. And if you look at it, the paragraph that they're trying to, well, and here's another thing. If in fact it was the intent of the parties to arbitrate post-judgment proceedings, that provision would clearly have been stated in the arbitration agreement. There would have been a paragraph that stated the parties agree that any post-judgment disputes shall be referred to arbitration. But this particular settlement agreement and the subsequent judgment of divorce did not include that language. So to the extent that they're trying to frame the issue that it was the judge's misinterpretation of the law, that's not my understanding of what she was stating. What she was explaining is that in order for the court to refer a post-judgment matter to arbitration, there must be an agreement of the parties. And, all the other provisions of the Arbitration Act must be enforced. We didn't have a provision in the judgment or in the settlement agreement that indicated it would be post-judgment proceedings.
Sas, I have a question.
Yes.
In that arbitration provision, so it goes through, it states the arbitrator will arbitrate any language disputes regarding any subsequent settlement documents, including the final confidential settlement agreement, the judgment of divorce, and any ancillary document security provisions and collateral. And your position is that that deals with everything before reaching the final judgment.
Correct.
Okay. And then what about then, and the arbitrator also will arbitrate any disputed issues described in this agreement as being subject to arbitration. Does that not open the door again to other issues that are subject to arbitration? Or let's talk about that a little bit.
Well, in the judgment, if I didn't review what other provisions were subject to the arbitration, but typically, for example, and I'd have to look, I'm just telling you anecdotally, that perhaps a lot of times we'll say in the judgment of divorce that if there are any disputes about the sale of the marital home, that such matters will be referred to arbitration. And I'm not sure if that's in here, but in order for arbitration to apply, it would have to be a provision that was specifically outlined in the settlement agreement. And, there was things that the court that were crossed out, and perhaps those were provisions that were going to be subject to arbitration. But typically, I mean, if you're going, again, if you're going to arbitrate a post-judgment dispute, the settlement agreement and the judgment of divorce would have to specifically identify that the arbitration clause was also subject to post-judgment disputes, which we don't have here.
I need to look at it more closely, but I don't see any other provision in the settlement agreement specifying that this isn't a subject to arbitration outside of that arbitration clause. Do you know if there's something that you know about and can point me to?
I'm looking quickly, Judge.
But I'll just say, assuming that there isn't, what does that latter phrase mean within the context of the settlement agreement?
Well, my preliminary look at the settlement agreement, I would agree with you that there is nothing else that's identified here. But what that means, in my opinion, is that it would have to be something that was described in the agreement. And from experience, I could tell you that certain things such as the sale of the house, if there's a dispute about the sale of the house, then that matter perhaps could go to arbitration. I don't see that in here specifically. But there also is there are a lot of items that were initially drafted that were blacked out, and perhaps one of the blacked out items stated that, but it would have to be a disputed issue described in the agreement.
Isn't, I guess, the plain language of the issues for arbitration, language disputes regarding any subsequent settlement document. Subsequent is the key. Well, this document that they signed that the dispute is over isn't a subsequent document. So what import do you make of that it's not a subsequent document that there's a language dispute on. It's the primary document that was incorporated into the judgment of divorce.
Well, again, subsequent settlement documents would include the drafting of the judgment of divorce. Because it's very typical that even though parties have reached a settlement on all issues, that when it comes to drafting the judgment of divorce, there are disputes about the judgment. And that's why in this agreement, it's indicated that the judgment of divorce itself is a subsequent settlement agreement, because the court can't just adopt the settlement agreement. We have to have the judgment of divorce drafted. So that's really what that means.
Okay.
So
Any other points you want to make? I think as you can tell, we've focused in on.
yes, I
and
appreciate your diligence.
We're honed
I
in on.
appreciate the diligence of the panel, so thank you for that. The only other thing I'd like to touch is on attorney fees. The plain language of MCR 3.602D2 does not indicate that a party must be held in contempt in order for there to be an award of attorney fees. Here, what the judge indicated was that although she found clearly that Mr. Varchetti had violated the judgment of divorce, she said on the record that she didn't believe that we needed to address it any further, other than the fact that my client should be compensated for the fees incurred because he did in fact violate the order. So, there's not a preliminary requirement under the plain language of the court rules that there be a finding of contempt in order to award fees. And I believe that is what appellant's argument is. But it's undisputed that the judge found that he violated the judgment of divorce. I don't think there's any argument that he did. He caused my client significant harm insofar as not only she was sued in Florida for her failure to pay her expert's fees. And it was clear in the judgment he was supposed to pay up to $160,000. It was clear he didn't. He wanted to portray a different interpretation, which the court rejected. And under the circumstances, the judge was correct in awarding attorney fees.
Okay.
One other final comment.
One question about that.
Oh, yes.
So is it your position that the attorney's fees award had nothing to do with the quadro?
Well, I don't think the judge was specific on that. So
The reason I ask is because counsel for your attorney said on the record, the only issue we need to deal with is Mr. Price. And that came after he explained to the court that the quadro had now been signed.
correct. So
So the quadro is off the table as far as the trial court judge was concerned when the trial court entered that order for the $2,000 attorney fees. Can we agree on that?
I would agree with you there. Yes. So one other thing in final closing is that I'd ask that the court affirm the judgment of Macomb County Circuit Court. And then also, because taxing of costs has been an issue ever since we have a new sheriff in town, I'd ask that the judge, I'd ask that the order also include a provision that allows my client to tax costs. Thank you.
Thank you. Counsel, some rebuttal?
Very briefly. Ms. Wade incurred no attorney's fees in Florida. She represented herself to secure a collusive settlement. So the idea that she was aggrieved by my client's conduct wasn't correct. And answering your question, Your Honor, on the phrase subsequent documents, and doesn't that
I was going to ask you that if you didn't address it.
I
Very
saw the red
astute.
flags. This document was incorporated into the judgment of divorce, which came afterwards. And so our position is that this is the judgment of divorce because it incorporated it. So after the judgment of divorce was entered, you get a subsequent document, a document subsequent to the settlement agreement. And therefore, interpreting the judgment of divorce, including this incorporated document, does fall within the arbitration provision because all of that happened subsequent to the signing of the marital settlement agreement. I hope I didn't confuse that timeline too much.
No, I understand.
Okay.
I understand your position that by act of incorporating it is in, even though it was not a subsequent document at the time it was drafted, it became a subsequent
Correct.
document. Okay.
Correct.
That's your position.
That's my position.
Understood.
And counsel referenced, the habit in the family law area and, what you typically see in agreements. But she cited no case law, no statute, no rule that said an arbitration provision covering post-judgment disputes must expressly state that it covers post-judgment disputes. It's the plain meaning rule that applies, and we argue the plain meaning would cover this. Finally, on the attorney's fees, there has to be some basis for awarding fees. It can't just be, you came before me twice. I didn't like your argument, so I'm going to make you pay fees. And the judge didn't really make any findings or issue any basis. She just tagged my client $2,000 essentially, from what I could tell, because she didn't like our argument, but that's not a sufficient basis for that kind of sanction.
About the argument council makes that the heading of arbitration is drafting and disputes. In other words, she's suggesting that, well, you heard her, she's
Right.
suggesting that the arbitration clause kicks in if, you know, they sign this settlement agreement and then they go to enter the judgment of divorce and they can't agree on what's going to be in the judgment of divorce. So in that situation, we send it to the arbitrator.
Because it has the word and. It doesn't say drafting disputes, which would be what council described, where you're trying to draft a document and you have disputes over the language. It says
Both.
drafting and disputes. So I think that strongly supports our side that any dispute that arises based on the language of these agreements must be arbitrated. So if there are no other further questions, thank you.
Thank you. Thank you. Very well argued, very well briefed. That case is submitted. Calling item number 13, consolidated case numbers 370452 and 370821, Alfonso Washington, the Nationwide Mutual Insurance Company. Counsel, please approach and state your appearances on the record.
Good afternoon, Your Honors. Judge Patel, Judge Trebleclock, Judge Wallace. It's great to be here today. I'm Pradeep Savantanathan on behalf of the plaintiff appellant Alfonso Washington. Now, I noticed today that not a lot of my colleagues were resting on their briefs. That is something I intend to do today. I just wanted to highlight a few points and make a few or highlight a few things that were not included in my brief. As you know, because I'm sure you've read all of the briefs in the law already. This is about two issues. One is, and I'll go with the easy one first, 500.3173A4, which is the statute that disqualifies a claimant from receiving PIP benefits due to assigned claims if they've made a false statement. This is a very simple issue on appeal. There was no statement made to the assigned claims in respect to the question that was being asked, which was, did he have any pre-existing injuries? He left that section blank. There was no statement, so that there cannot be a false statement. Of note, and what was not included in my brief is that entire section 3173 was part of the no fault amendments in 2019. If you look at every section 1, 2, 3, and 5, they were all significantly amended. Only one that was not amended was the section that is we're talking about today. They had the opportunity to amend and include omissions, and they didn't. So what we have here is that the claimant has to make an affirmative false statement in order to be disqualified. I think that's pretty clear. The next issue is whether or not someone who does not have a valid driver's license, whether that is considered an unlawful taking. I think my brief covers it pretty well. There is Spectrum, Ramblin, VHS, Monaco, Bradley, and Pina Cruz that all state the same thing.
Thank you, counsel.
Thank you.
Any
you.
questions?
No questions.
Well, you have time, obviously, for rebuttal if you so choose to use it.
Good afternoon, Your Honors. Jeff Peachtree on behalf of defendant Appley, Nationwide Mutual Fire Insurance Company. Just for purposes of housekeeping matters, this was later assigned, actually Nationwide renamed to Titan, which then reassigned it to Mackinac. So if I say Nationwide Titan or Mackinac, I'm actually talking about the same entity for purposes of today, as if it wasn't confusing enough with the consolidated appeal. I will take brother counsel's points in the order presented, which was with the material misrepresentation first. I think the analysis based on a statement needing to be some kind of affirmative generated statement on a document is misplaced. The way 3173A4 reads, just it includes a statement and also computer generated information. The application for benefits is a computer generated statement. That's a statement in support of a claim. In that, Mr. Washington failed to disclose obviously material things. There's no question that these were false. There's no question that these were knowingly false.
If I can stop you, it was computer generated. If it was mandatory to fill out, I fill out forms all the time where I get them kicked back to me if I don't fill out mandatory form. There's a little red star asterisk. Why is a person who's applying, maybe they miss it, they click too fast, they're doing it on their phone. Lots of reasons why they could leave it blank without having any intent to commit a fraudulent act or, defraud anyone. Why? What's your response to that?
Well, my response to that, Your Honor, is that there has not been, I do actually think that I would welcome a precedent that says the application must be filled out in full. That's not the precedential era we live in right now. It's been held before by trial courts and other courts that the application need not be completed in full. With that in mind, while the MACP and the MAPF certainly do send applications back for further clarification on certain points, the law does not that you must.
Why isn't
fill
that
out
end of story then? If it's not required, person leaves it blank, how is that a fraudulent statement then? If it's not required to be filled out?
Well, a fraudulent statement, there's no intent element. Simply the submission of the application for benefits. What I'm saying, Your Honor, respectfully, is the application for benefits is the statement. The knowingly false information on the statement is omitting the prior conditions for which the claimant was currently litigating another case. Part of the
Well, anytime a space is left blank, or filled out incorrectly, that's fraudulent?
Well, I'm sure, Your Honor, hypothetically, one could think of a scenario where that may not be true. However, I think if we look at
I think I could think of one from this case.
Right.
So here, let me tell you, let me ask you. So the whole point of filling out this application is for this person to get their medical bills paid and whatever other benefits they might be entitled to, right?
Correct.
Well, you notice he didn't even fill out the part of the form that said who he's currently treating with, which is basically where he's supposed to tell the MAIPF, here are the doctors that I'm treating with so that you can pay their bills. He didn't even fill that part. So to me, it looks like sloppiness as opposed to any kind of fraud. He just didn't finish filling the thing out. I mean, it was 100% to his benefit to fill out the section that said which doctors he was seeing so that MIIPF could pay those bills, right?
Correct.
And he didn't fill that part either, right?
Correct, Your Honor.
So, I mean, doesn't that lead us towards towards the finding that this, rather than fraud, it just didn't fill out the application. It was sloppiness.
No, Your Honor, I think actually, Your Honor, I certainly see where you're going in terms of sloppiness. However, that's not the standard. The standard is knowingly false information. I think the egregiousness of the knowingly false information that he was actively litigating another case doesn't support the plaintiff's assertion that this was no harm, no foul situation. It supports the defendant's position that this is so egregious that how do you miss this?
Well, was it knowingly false that he didn't tell MAIPF which doctors he was seeing right now?
Well, the knowingly false information.
I mean, what was it or wasn't it? Maybe it was, maybe it wasn't.
Yeah,
I'm wondering what you think.
Well, yes, Your Honor. A part of our briefing certainly touches on the fact that an omission is in itself a declaration of the standing nature of current, the status quo, so to speak. The fact that Mr. Washington filled out the other information on the application shows that there was an understanding that this needed to be filled out. In the prior application for benefits, he did fill that section out simply because the egregious nature and the obvious, how does this happen? That supports the defendant's point, Your Honor. And furthermore, I think what's important too is this wasn't a concurrent happening in the sense that it wasn't, I'm filling this application. Well, this case is being litigated by the defendant where it's going directly to Nationwide. This application happened. The whole reason Farm Bureau was previously in this case was because Mr. Washington denied that he had made a prior insurance claim on that same application and then left all this information blank. So it gets sent to Farm Bureau this is why he went through 2 depositions. We found out about the second accident during his first deposition. That hadn't even been brought forward yet. So obviously, when we're talking about materiality and knowingly false statements, materiality is clear. The impeding of the servicing insurer or the MAIPF's ability to discover the claim and do its statutory duty, which is presumptively, and what trial court judges always say needs to happen quicker and quicker and quicker, is the ability to ascertain this information.
So in action A, you find out about the accident from accident B, right? And then the action for accident B, he doesn't fill out a form telling you about action A, which your client is a party to, right?
Nationwide was a party to, the MAPF was not,
Yeah,
yes.
well, but they were assigned by MII,
Sure.
yeah, right. So you're essentially saying he committed fraud because he didn't remind you that you had this other case that was pending with these other injuries.
We are saying that the knowingly false statement in support of the claim was the omission of that information from the first claim. Yes, sir.
Even though your client knew everything about it, so they had already taken his deposition.
We didn't know about it at the time of the deposition, Your Honor. This wasn't discussed. Again, Farm Bureau was not dismissed and matter reassigned until the litigation had already proceeded through discovery in this lawsuit.
Farm Bureau is an assignee of MAIPF, correct?
Correct.
They're charged with all the same knowledge MAIPF has because they're an assignee, right?
Correct. However, Your Honor, there is no part of 3173A4 that says, well, if they later find out about it, then it's fine. That was part of our briefing material, was that when he submitted it.
Later find out about it, and B, they knew about it when A started. They already knew about it.
But the statute, Your Honor, respectfully doesn't require any of that. The statute, Your Honor, simply says a person who causes or presents a statement. I'm paraphrasing the statute right now, but I'm happy to read the whole thing if the court would prefer.
That's not necessary.
Right. A person presents a statement or thing in support of a claim containing knowingly false information that's material to the claim. Those are the three elements. If those three elements are met, a fraudulent insurance act has occurred. In this case, it's undisputed that all three of those things occurred.
I think we understand your position on that. What do you say about the first argument and the valid driver's license and whether that's a unlawful taking?
Sure. Thank you, Your Honor. I think swoop looms large over that issue. I think the facts are fairly analogous to swoop, and swoop. I do believe since the time of the briefing submission, the oral arguments have taken place on that. But the facts are certainly analogous there. But however, where I'm coming from on that particular issue is procedurally, as a procedural matter, the plaintiff has presupposed that there's no debate that he had permission to drive the vehicle. That's completely untrue. It's quite the opposite. There was no investigation made by the plaintiff into whether he had permission at any point. In fact, on his application, he said he didn't need to get permission. He never stated or testified where he got permission from. Plaintiff did not try to depose the owner. We tried to depose the owner, who's a co-defendant, who is seemingly absconded, even though it was his girlfriend at the time. And through some point here, my position is with the information before the trial court judge, the judges respectfully, you can't find that the trial court judge did anything wrong when the trial court judge, with the information before him that was produced during discovery, there was no dispute that he never tried to find out if he had permission to drive the vehicle, didn't think he needed it. And so the information on the application for benefits, again, in the first one, which is what we had to rely on in that situation, said he didn't need to get permission. Therefore, that seems to indicate that he didn't try to get permission. And as the case law is,
He had it.
pardon, Your Honor?
He thought he had it.
There's no information that would lead one to say, I think I have it. He didn't test. He said he didn't need to look for it.
Well, he said he had permission to use it on the application, didn't he?
He did, but not from whom?
Your client's next question on this form is, do you ever have to have permission?
Correct. However,
and your client created that question. He didn't.
Correct. The application, and at no point did he say from whom he received permission.
Isn't that inherent in whoever owns a car, whoever controls the car?
No, I think the case law is, sorry, Your Honor, I didn't mean to interrupt.
That's okay, but I mean, isn't that inherent?
No, in the case law and plaintiff's own cited case law on the Peña Cruz case involved a situation where the vehicle, and several of the unlawful taking cases involve a situation where the vehicle owner has the vehicle in possession of somebody else, and then some third party is the driver. So that is very similar to a situation like we see in that case where the F-150 is owned by one woman who says to person A, you can have possession of this car. Person A then allows person B, the claimant, to drive the vehicle. Person B thinks, well, I had permission from this person, but I never even asked the actual owner of it. That is similar to the hypothetical being presented at this point, Your Honor. However, my point is that this does not even get to that because Mr. Washington took no steps to demonstrate through evidence, through anything in the briefing, at any point at the trial court level, that he did have that permission.
Doesn't him saying on the application, to Judge Wallace's point, isn't that he's met his burden to say, look, I checked those boxes and it was mine, and now it's the burden shifts to you to say, no, he didn't?
Respectfully, Your Honor, that is not what that question indicates. And that's what the trial court judge did also determine, was that the facts mirror those of Swoop, where once one element of you need to go check for permission is you did not have a license. And Mr. Washington, what he was emphatic about is acknowledging that he did not have a license and he knew it was illegal to drive without a license. After that, it behooves him to dig into this permission aspect. There was no evidence shown by the plaintiff other than, as shown in this briefing as well, that, well, it goes without saying that I have permission, but that's not how it works. And that's why Swoop was decided the way Swoop was decided, which is you needed to do something. You didn't bother even getting that permission. That's what happened with the claimant in Swoop. And the Court of Appeals said, that's not good enough. If you didn't have a license, you needed to check with that owner. You didn't even bother checking with the owner. And there was nothing here that showed Mr. Washington checked with the owner. And that ship has sailed now. We tried to get that information and we couldn't. Plaintiff has sued Ms. Middleton. I don't think it goes without saying then that he absolutely, without question, had permission after that, Your Honor. I don't think that's true. And I don't think that follows from checking that I have permission on the application. I don't think that those pieces of information, while they can be a start to proving one's case, they are not in itself checking one box. I have satisfied my burden of proof. And that's what the trial court judge found. And therefore, I don't think this court can say that was a reversible error to find that way.
I think we understand that argument. Anything else you want to add?
The rental car case?
Ahmed v. Tokyo was the rental car case. Swoop was, yeah. Ahmed was the rental car case. Swoop was the one very recently with the facts were similar to
the Supreme Court. Yeah.
Correct, Your Honor. I think it had brief oral arguments around Halloween.
Anything else?
And you're certainly not asking us to take this hold it under abeyance.
Well, I do ask for that in my brief. In terms of my argument before you, I don't think it actually gets to that point, but I can't help but acknowledge a similarity in fact pattern to Swoop. So I would say, just like the Painted Cruz, Bradley, VHS, all those cases that have been held in abeyance awaiting Swoop, I am realistic in the sense that I think this follows that. However, again, my point through my briefing that I was trying to get across, and maybe the nuance may have been missed a little bit, is, there's a Rubik's Cube when it comes to unlawful taking right now as to a license, a permission, who the owner is, the scope of the use involved or allowed. I don't believe that the trial court erred in saying you aren't even getting to that Rubik's Cube because plaintiff, you've not produced a single shred of evidence at the dispositive level to show that you even made a question about whether you got the vehicle, and you're not going to be able to do it because discovery is closed. That's really my point. So I do acknowledge that Swoop is obviously looming large.
All right. Thank you for your argument.
Thank you.
Rebuttal.
Thank you. I think my briefs cover all of the rebuttal I would be giving right now. Do you have any questions for me? I'm Swoop, anything?
No.
Okay.
No questions.
All right. Thank you.
All right. These consolidated cases, item number 13, will be submitted.
But now that we're done, I do have a question. Are you related to Sam Peach? Yeah, my dad. Oh, well, say hello to your dad for me.
Okay.
We used to be in the same building many moons ago. The Gem building?
Yeah. Yeah. I'm dating myself a little bit. I remember being
Yeah, yeah.
That's how old he is.
We probably met at the time.
Yeah, no, for sure. I'm sure you're on it. I'm sure. But no, I appreciate that. He's still practicing.
Oh, okay. Sounds good. Have a good day.
All right, moving on to item number 14, consolidated cases number 373-543, 374-600, in re KH. And I believe that may be the case. It's on remote.
Good afternoon, Your Honors. Can you hear me?
Good afternoon. We can hear you. We
Very
can't
good.
see you yet, so hold on a second.
Oh,
There you go.
okay. Good afternoon. Michael Skinner on behalf of KH. So I do not have an opponent in this case. Mine was the only brief filed. I would be happy to take any questions, and otherwise I'll just make a few points for a couple of minutes. So this is a mental health case that's been, it's got I think an 05 case number. I mean, it's been around for 20 years. Over the past few years, there have been an increasing number of petitions by KH's family for involuntary hospitalizations. And I think there are two basic problems with the case, and they're sort of interrelated. One is that the family is using the petition process in an improper manner. And unfortunately, because of I think it's really just the inertia of being an old case, they keep getting granted. They keep getting granted with insufficient, factual basis. The petition that is in one of the cases here, the February 10th order. The judge ordered the evaluation and the temporary hospitalization based on KH being a danger, whether to herself or to others. When on the record, the petitioning family member said that she wasn't a danger, that's not what this was about. And so they're using the petition process to sort of manage KH's medical treatment, which is not a proper basis. These temporary hospitalizations, I mean, there were multiple things missing. There wasn't an allegation of danger. There wasn't proof of danger. There wasn't any doctor's certificate supporting the petition. The substitute for a doctor's certification is proof of reasonable efforts to get KH to be evaluated. They had a one-word conclusory statement, refused, no facts on the record about that. And then further, when you look into the file, KH has made herself available for these independent medical evaluations to demonstrate that she does not need this sort of intervention. And the two evaluations, the most recent ones by Dr. Sewick and Dr. Abramsky, both said, look, it's not there. This doesn't meet the standard of what we're looking for when we're talking about an involuntary hospitalization. So it doesn't meet those standards. And the consolidated part of the case is KH's request to get a protective order to stop her family from taking these sort of actions. So ultimately, the relief that we're looking for is, in the form of some sort of, 1, 2, 3, and the alternative. One, we're looking for just a protective order to stop these petitions. They've been increasing over time, the frequency of them. And again, it of course is tied into the fact that, the court is.
Counsel,
I'm
is the
sorry.
basis. Yeah, counsel, is the basis of the foundation of your legal authority to issue the protective order, is that based solely in MCL 700.5401?
That and generally the courts
Inherent authority.
inherent authority to limit sort of vexatious litigation.
Okay.
So, we would be looking for something that says, every time they come to the court with these petitions, they aren't meeting the standard. So again, as I was saying, it's sort of tied in with the judge. The judge is in error by signing off on these petitions. So it's a vicious circle that's going around here.
Counsel, isn't the relief, isn't it? Remind me what county this comes up in from?
Oakland.
Oakland. Wouldn't that have to go to the chief judge of Oakland County? Because if the judge, one judge entered the protective order, the other judges on that panel, in my experience, aren't necessarily controlled by that order of one circuit judge. So if they filed a petition and it was assigned to another judge, that judge wouldn't necessarily have to, follow that order. Now, a lot of times they do, and it's persuasive and all that.
They wouldn't have to follow, I apologize, Your Honor. They wouldn't have to follow the protective order, or?
Correct. If one court issued an order saying that you can't file any more of these without posting a $5,000 bond, say, or whatever it is, that would be controlling in that judge's courtroom. It would not be controlling in all the other judges' courtrooms.
I don't know if that, honestly, number one, I don't know the answer to that. Number two, this is case is 20 years old. It's my understanding that it just stays with the same judge. It used to be Judge Hallmark. It's now Judge Callahan. I don't know why the petition will go to somebody else.
Okay.
And frankly, I guess I would say, this is all just off the top of my head, is that, okay, it's in another court, but again, it's still the same case. Now, having said that, they sort of interim order. It's sort of an ongoing litigation. I suppose a new judge could look at it and say, well, I'm basically going to treat this as sort of a reconsideration, and I'm going to, lift the protective order. I'm going to do something else. Yes, there is the danger of that. What we're trying to do is, as we said in the trial at the trial court level, we're not trying to stop third parties or law enforcement or anyone else if there is a legitimate mental health issue that needs petitioning. We're not trying to stop that. We're trying to stop specific people from using this process incorrectly. That is our ultimate goal. However, I will also say that, as I said before, sort of in the alternative forms of relief, look, we don't have a time machine. We can't go back and, give KH those weeks that she spent in the hospital back to her. But if this court will say, even if this court doesn't say, yes, you get a protective order, or we send it back to the court to consider a protective order, because the judge didn't even think that she had the authority to grant a protective order. If you put the protective order to the side, at a minimum, I'm looking for an opinion from this court that says, these orders that are being entered improperly. They're being entered without sufficient evidence. They're being entered, without the factual basis, and you're skipping over things. You're letting, again, the inertia of the case move you forward instead of looking at what are the actual allegations of the petitioner. Are they supported? Do they meet the criteria?
We understand, counsel. It's well briefed, and we
Very
understand your emphasis of your points. Any questions?
So, I think the trial court essentially said she didn't have power to do that because under, 5401(3)(a) and B, they don't really seem to apply to her. And so can't you just file a petition for a PPO in circuit court?
That was the judge's suggestion. The number one, we did that and we failed. Number two, because, and you'll see in our brief, we go through it. The reason that we failed is because the PPO doesn't really fit. PPO has, there's sort of three different things that a PPO can cover, and it's not covering these things. It's not, which is why, I'm falling back on, and I think the better support for our argument is the statute and the inherent authority of the court. I think those are the correct ways to prevent this problem. The PPO, just the statutory protections don't cover, vexatious litigation.
Okay, thank you. Anything else? Anything else? All right, these cases will be submitted. Items number 14,
Thank you,
consolidated.
Your Honors.
Thank you. And the last item on today's docket is item number 15, case number 375-685, In re G.A. Burns minor. None of the parties are certified for oral argument. I don't see any attorneys or parties in the courtroom. So that case will be submitted and considered on the briefs. And with that, this closes our case call for today, and we will be back tomorrow.